with your Lordship's kind request, Lord, we discussed among ourselves. It will be difficult for all of us to finish by 2 minutes. Because the 9 judgment, it's not going to have far-reaching consequences.
See, we have to conclude the matter by lunch tomorrow. Because all of us have regular benches after lunch tomorrow.
Yes.
And we have the call of conscience towards other litigants who are waiting for years.
Yes.
So we have to get back to our regular benches tomorrow afternoon. Give an hour to Mr. Rakesh Dwivedi today. So if he starts at 3 o'clock today, he'll get 1 hour today and he will get 2.5 hours tomorrow morning. So 3.5. Between you divide it.
We'll
so that
divide ourselves.
Give us a small note by the morning tomorrow. Just 2 pages, Mr. Dwivedi, because we've made very detailed notes. But just what the punch points which we are going to make in response to what they have argued.
That's very kind of you.
Lord, we'll also we'll give our punch points. After
I think so. If you we'll give you until 3 o'clock and then you can.
So let's start.
Grateful.
I'm deeply obliged.
We completed before the time.
So these are the matters to be detagged. The nodal council have given us the 2 matters to be detagged.
No,
The nodal council have given it. I presume that everybody.
What I would request is, Lord, that they may not be detagged because some of the issues are common, like royalty, what is royalty.
Some matters.
So, Your Lordship,
Right.
submissions will be limited.
We'll not detag it right now.
At the end of the
At the
day-
end, when the judgment comes,
Then they will go before the appropriate bench for the.
bench.
Yes.
Or below.
May I request, my lord, so far as 2 matters are concerned, my lord, ONGC and oil. If your lordships can consider recording that in view of the affidavit of MOPNG, since they have a separate regime, the matter is detailed. Whether now or at the end of the judgment.
we are fair enough, no difficulty. Who's for the, so long as both the learned council are agreed in this course of action, we can do it. There's
No,
no
because
difficulty.
I'm appearing for state of Assam.
Lord, I pray for Oil India. Mr. I'll agree with the solicitor, Lord. There's only one
And
issue is.
Mr. Dwivedi is appearing in that very matter?
Yes, Lord, it's for state of Assam, Lord. My side, what is royalty will be common there.
That's
Lord.
common.
And
Lord, let it be
49
tomorrow,
will be
my lord,
common,
possibly.
so-
Yes.
Possibly,
So
Mr.
what we
Dwivedi will agree, my lord. Kindly.
between 2 or 3 seniors, if you could look at all the matters on our board,
Yes.
right? Eventually, these matters will be sent to a regular bench. But whatever matters are to be completely detagged. If you can just make a little list, if you sit for 15 minutes between all of you over a cup of
Yes,
coffee.
we'll do
you can
that.
be able
So
to
that
give-
will go separately after the
But
judgment.
as
After
far
the
as,
judgment.
ONGC,
Sir,
Oil India, no, what solicitor is right. They are in a different regime. The only thing he was mentioning.
Mr. Dwivedi, what is
No, Lord,
royalty?
I-
We are
Can I
hearing
say
you.
something?
Whether we detag it or not, we are not going to deny
No,
permission.
so the
only on-
state will be there. I will not be adding anything new on that, my lord.
All right.
Whatever I'll say will be equally applicable.
Anyway, my lord, may I say,
Those matters.
Lord, the only additional point in.
Lord, may I,
Yes,
Mr. Datta, if you don't mind, Mr.
Yeah.
Datta, if you don't mind, but possibly I'll be able to persuade Mr. Dwivedi by tomorrow. I'll mention tomorrow.
all right.
State of Assam may be agreeable.
All right.
It will require some.
very loaded comment. Very loaded comment.
No, lord, I
He's
request.
going to make him an
I
offer he
persuade
can't
Mr.
refuse.
Lord,
Now, let's-
the only interesting point there, which solicitor will point out. Assam fresh levy tax on the entry 14 and list 2 on the oil bill.
We are not arguing that, Mr. Datta.
No, I'm not arguing. I'm just mentioning that.
For a private party there, don't do this.
All right. Let Dr. Singhvi begin then.
Now, it's 10:45. I am going to crave your lordship's indulgence to read from the note the extract. Otherwise, it will take too much time to go. I'm going to race along.
Certainly.
Your lordship will allow me some speed reading
Certainly.
with apologies
Where
to
is
your
the
lordship.
note, Dr. Singhvi?
Yes. 305 it starts, but it is not in the, I will take your lordship's back and forth. So your lordship follow my para numbers. I'll tell your lordship.
To
Volume 2E.
E.
2E 305. And well, there'll be no repetition. Most of the points are new and I'll race along with your lordship permission. I'm going to keep to the time, Willis, to the maximum extent possible. Is where it starts.
Dr. Singhvi, just give me 1 second. That's all. I complete.
P05, as I started yesterday, has my 6 propositions, seriatim. And my lords had heard me briefly on each of those 6 yesterday.
Yeah.
There is one point I must point out, the paras I have given against each proposition, which are valid.
Right.
But the pages have been changed by the person who manages it.
Yes.
So my internal pages have been taken away. You should be having the new pages, I think. Right. Now, the first point I wish to take your lordships to is royalty is a tax. And I've broken it up because I'll be reading less than half of these paras, but lordship will allow me to go in my sequence in that. Because what are the elements of my first proposition? Royalty is a tax. The elements are: number 1, your lordships cannot ignore and must not ignore 366(28). It's a constitutional provision. For ease, it is quoted at my B3 at 325. That's the way I want to proceed. It will be much faster. My B3 at page 325. The elements are that your lordship has an inclusive, which means an expensive definition of tax. In a sense, tax proper and akin to taxes or deemed to be taxes, which are imposts. The characteristics are given in my B3, page 325. Tax or impost, general, local or special. So it's an inclusive, expansive approach. Now, it is so understood, going back in my para B1, in not merely general cases, but in extremely important general cases. Para B1 is at page 325. I've given a list of your lordship starting from Shirur Mat, 7 judges. All of them reiterate the famous dictum of a tax by Chief Justice Latham, which is my first para. All of them. I ask myself, which is the element of this missing? None. Is it compulsory? Answer, yes. Is it public authority? And most important, enforceable by law. I know a lordship has 2 queries. One is royalty is not a tax, it's a share or a consideration. Second is it's charged by private persons. Please leave it for 2 minutes. I'll deal with both of them.
So what are the ingredients for compulsory?
Just see B1. B1. Your lordship need not note. B1 has them. Underlined, highlighted. 3 to 5. That's why I said it will be faster this way. This chicory is cited by your lordships in 7 judges, 5 judges, and 9 judges. Shirur Mat was 9 judges. Jindal is 9 judges, Shirur Mat was 7 judges. Next para cites them. Shirur Mat is 7, Jindal is 9. So, all the elements are satisfied. Now, the case which alone I want to read, I'm skipping, is McDowell in B5, which is 326. And even in the cases, I'll read only the highlighted portions. B5, 326. May I read the second half, para 22, if your lordship has got at page 326, quotation of McDowell, all my lords have it.
Yes.
Under 366(20), this is a constitutional article, how can it be ignored? 366(28). Taxation has been defined to include the imposition of any tax or impost, whether general or local. Impost means compulsory levy, non-volitional, not optional. The well-known and well-settled characteristics of tax in its wider sense includes all imposts. Impost means 1, incident of sovereignty. 2, law means an act of legislature. We know 265 very well, Malas. The term tax under 265 includes imposts of every kind, tax, duty, cess or fees. And the idea of 360(28) is to be expansive and inclusive, not restrictive.
Dr. Singh, the problem with your argument is very simple.
Private and...
If your argument is right,
yes,
that would mean that wherever a contract is a statutory contract,
yes,
that it is a contract within the fold of a statute, not just regulated by a contract, but there are statutory contracts. Then any payment which is made under a statutory contract becomes in the nature of a tax. We'll have to go as far as
no, you should not have to. Give me a...
Comes down to that.
No, it will not have to. I assure my lords. Your lordship will have 2 considerations which fell in the open argument which I was hearing earlier. 1, if it's a tax, how do private people collect royalty? That was one argument. Against the open argument which I was hearing earlier. The second is, royalty is not a tax. It's a tax. It's a share or a consideration. the judgment from the against
Yes, we are
Saurashtra,
answering in a minute.
Gujarat. The second is,
One,
these two I'll answer in a minute. Lord should be satisfied. I've dealt with it. But first,
judgment
I'm on
from the
the
one
elements of a taxation, which
The
McDowell.
license fee which is paid
Yes.
for the state to partake, or for the state to part with the
Lord should be satisfied. I've dealt
privilege
with it.
of selling
But first,
alcohol
I'm on
or
the
liquor,
element.
it becomes a tax. It's not a license fee by this.
Well, if it's a
The
statutory
state,
contract,
because the state parts with the privilege to deal in liquor,
yes,
right?
yes.
You pay a royalty, you pay a
I'm
license
going to
fee.
say it's a tax.
It's a tax.
No,
By
I'm
this.
not saying it's a tax. Whereas if your lordship has, contracts, ultimately, under the law, are contracts, whether they are under the fold of a statute or otherwise. So there will be consenting parties with a contract to which I cannot argue then that that's a tax. I'm going to say it's a contractual fee. There is no contradiction in my argument. Whereas it will remain a contractual, consensual payment. Somebody will pay 10, somebody will pay 20, longer term, lesser term. It is contractual, it is not tax. The real only two questions against me on this section are the private person collecting royalty, which I'll demonstrate in a minute why it's a wrong argument, and the Saurashtra High Court judgment. I'll deal with them in a minute. So first, your lordship has got B5 at page 326.
Yes.
Clearly, the characteristics of a tax are satisfied, absent those two contra points which I'm coming to. Now, on this, my conclusions, if your lordship doesn't mind, are at B13 at 328. This conclusion, so lordship, see, I'm skipping large portions with your lordship's permission. Then I'll deal with those two contras in a minute. May I read B13 at 328? My lords have got it. Royalty and dead rent is a compulsory impost under a statute and not a result of negotiations leading to a contractual agreement. It is unilateral. The mining lessee has no say in its determination. The rate of royalty is fixed by the Parliament in the second schedule. Now, this is a very important characteristic of a non-contractual impost. Your lordship fixes it in the schedule. No options, no discussions, no consent, no negotiation. And can be varied or amended by the central government, subject to limitations imposed by 9(3) by a mere amendment. The rate of dead rent, which is actually a more important example, not been given sufficient weight in 9A, is also fixed by the third schedule and can be varied or amended. The recovery is capable of being enforced by coercive means. Your lordships, in that very relic of the past, that contractual exaction of royalty by a private contractor, does not have 25 enforceability. Then, hence it is submitted that royalty meets all the requirements of at least an impost. Then, your lordship will come to, may I just straight away take a lordship to the two contras, which I myself formulated against myself. One is at 328, para 15 onwards. This I have dealt with the Gujarat High Court judgment. Incorrect to characterize royalty as consideration. May I read through very quickly? It will be faster and easier if I read these paras.
Yes, very well.
Royalty imposed under 9(1) ought not to be conflated with the concept of royalty as consideration share of income, such as intellectual property, music, artworks. Such royalty would be determined through negotiations between contracting parties. Royalty in its very essence is based on removal, consumption. There are 9 judges. Your lordship has to lay down the concept one way or the other very clearly. This will endure for a long period of time. And is very interesting. Let me digress for 5 seconds. 4 months after India Cements, which held it to be a tax. 4 months. Learned judge who was a member of the India, who was heading the bench of India Cements, Chief Justice Venkatramaya as he then was, holds it as 4 months later that we held so, that is a tax. They did not misunderstand their own judgment, fellows. It's only the interpretation of Kesoram that you are misunderstanding your own judgment. Now, let's kindly see. Royalty in its very essence is based on removal or consumption of minerals. Although the terms removal and consumption are not defined, they are linked closely to the terms production and dispatch. These are directly linked terms. Your lordship has them defined 3A, 3FA. I'll not read them. Removal, consumption, products, derivative meaning of production or dispatch. I'm not reading it for saving time. Now, C customs is a general point. It's not on this. It holds that it is akin to excise. It's 7 judges, 9 judges. C customs is 9 judges. And just see the bold face on the next page, 330. My lord is saying, seeing I'm jumping, I'm only going to the highlighted portion. Lord will pardon me. I don't have time to read all. Excise duty is primarily a duty on the production. What is removal? What is dispatch? What is production? What is it, Willis? You don't call it excise, but it is in the nature of a duty. Excise is primarily a duty on the production or manufacture of goods produced or manufactured in the country. Next para. Therefore, both excise and sales tax, of course, are different taxable events, are levied with reference to goods. The two are very different imposts. In one case, the imposition on manufacture or production, other is an act of sale. Now, Malas, I'm not saying this is a case on mining. It's a general case. It is, Malas, now come to Hingir Rampur and the nature of royalty is more akin to that of an excise duty. Hingir, and if in Hingir, your lordship will just come to 331, the page number, fourth line, this raises a question as to what are taxes on mineral rights. Obviously, taxes on mineral rights must be different from taxes on goods produced. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under 84. A comparison of list 1 and 2 shows that the same tax is not put in both the lists. And whereas 50 is a unique entry, it uses the word tax on mineral rights. They don't use the word mineral development, they don't pick up the word from anywhere else. Therefore, taxes on mineral rights must be different from duties of excise, which are taxes on minerals produced. The difference can be understood. I'll skip those lines with lordship permission, come 4 lines below. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. This is actually my proposition 4. It's coming later, but the judgment is the same. Thus, tax on mineral rights would be confined, for example, to taxes on leases of mineral rights and on premium of royalty. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on the minerals actually extracted would be duties of excise. And then the last 4 lines underlined, not boldface, last 4 lines, same page. Therefore, the present cess is not a tax on mineral rights. It is a tax on the minerals actually produced and can be no different in pith and substitute from the tax on the goods produced. Now, Malas, Saurashtra, I know, has been cited against us, B19. I'll skip that because it is approved by Keshuram. Malas, I'm skipping that. That is cited in B19. Come to B20. Malas, what is the reason in Saurashtra? With the deepest humility, the reason is, if you don't want to have this tax, don't go mining. Well, is that an excuse? That's the reason given. Now read my para B20. Every indirect tax, fellows, in that sense is optional. If I don't go and buy a good, I won't have to pay the tax. So that means I should not buy the good. However, the underlying logic of this reasoning, well, this reasoning is the Saurashtra reasoning, Gujarat High Court. It is respectfully submitted, and that's adopted by Keshuram. That's the problem. Gujarat by itself would not have been a problem. It's adopted by Keshuram. It is respectfully submitted, patently erroneous, in as much as the choice of whether or not to undertake mining operations by obtaining a mining lease cannot possibly take away the character of royalty as a tax, for the reason that this choice is available with respect to all indirect taxes. One may or may not buy goods or may or may not avail services. That cannot possibly make the indirect tax that would otherwise follow something other than a tax. Now, Malats, who are the people operating this system? See the next paragraph. From time immemorial, apart from India Cements, apart from 9 judges, this is the Indian Bureau of Mines, which is the mother organization for all this. Royalty in the strict sense and common parlance may not be a tax. It can be viewed as a kind of tax, which is why 366(28). Linked either directly or indirectly to the intrinsic economic value of a mineral realized through sale by the lessee. Royalty of mines cannot be a fee, but a levy in the nature of the tax. Then next page, Balas, 333. Royalty on coal is a tax. Then, Malas, I move to B23. International Monetary Fund, Malas, not that it's at all in any way binding. It's a working paper. I've quoted that. Don't read it. It's saving time, Malas. I've quoted it there. Please look at it. Come to B24, which is on general interpretation, Malas. Your lordships can use an external aid, because some of these are external aids to interpretation. And now, Malas, just note on the side of B25, a conceptual point, which is not put like that. Your lordship has taxes which are royalty under 9. This lordship I have not put here. Lordship I want to note on the side of B25. Royalty is a tax under 9. Dead rent is a tax under 9A. DMF is under 9B. Only thing which I get a quid pro quo and a benefit is the 4th one, NMET, the exploration tax. That is 9C. That can go in the category of fee, but it's an impost covered under 366. It's the fifth one, which came in 2015 in my B25 para, which is a bidding parameter. That is contractual. That is not a tax. This what happens as well as after the auction regime of 2015, I have to bid. So I bid 10 rupees, he bids 20 rupees. On that bid of mine, depending on the bid, I have to give a share. That's my contractual thing. That's the fifth one which has come only in 2015, which I have quoted in B25. All the other are compulsory exactions. I'm only contrasting it. It's called a premium, but it's actually a contractual exaction, a contractual payment. And that is the closest to a share or a consideration. I'm contrasting it, Bills. And your Lordship, Bills, has got the B25 and B26 on that. Now, Bills, I come to the other contrapoint. If it is a tax, Mr. Singhvi, how do private persons collect it? Very simple answer, Bills. Let me give the answer first and I'll read the rule. Well, it is true that it is a relic of the constitutional past. But Bills, the tail should not be allowed to wag the dog, as was mentioned yesterday. This will be a case of tail wagging the dog. It is a very, very few number of states, and my learned friend relies on Theresima, Mr. Dwivedi cited it, which was Kerala, which had forgotten, I would use the word forgotten, to pass a law saying that the mineral under the earth is the states. Incidentally, after Theresima, Kerala immediately passed that law. Most other states, 99% have that law. It is true that there may be one or two examples, which I call a tail malice. That will not decide a 9 judges approach. That royalty is not a tax because 0.1% cases may be there in the country where the mineral does not vest in the government and therefore there can be a private lease for which royalty is paid. That's answer number one. Answer number two is very interesting, Willis. Is that even in those private lease cases, the 2016 rules make it clear that it is completely controlled by the government. Because the private man, he's the private lease owner, he can't give me a lease. He has to go through a gamut of prior authorization by the government under 2016 rules, which I'll show in a minute. And the third reason is most important. This private leaseholder cannot enforce through 25. That's the hallmark of a sovereignty of a tax. So, Malas,
What is the third reason?
Third is this private fellow who has a relic, well, a few occasional leases here and there in the country which have not been taken over by the government, cannot use 25 to enforce. The enforceability is given only to the, well, as exaction. Section 25 is clear. Now just read the paras in that light. 3 points I have given, Lordship, all three are covered here.
Sovereign function.
So B27
What is it regarding?
of my page, well, as 334. .334 is the Theresima Kerala case.
Yes.
At B27. At 335 page number of my written submissions, I have said in the first 3 lines, there was an absence at that time of a provision in the Kerala land revenue declaring the ownership of minerals underneath to vest with the state. That is, well, as one of those anachronisms. There is hardly a place, 99% would not be that. It's a relic of the pre-constitution position, which I have said. I don't want to read it, but second B28 is the section 25 point, which I just made. B28A, section 25 and 21 bracket 5, the recovery positions provisions would not be available to private lessors, thereby changing the very character of royalty. The grant of mining lease concessions by private person is not unqualified. Now see this authorization in rules 27. Where is that? The book you should have to take 2000. Actually, although the private man has the lease, he can't sneeze without permission from the government. All of it is regulated.
All right,
Well, rule 27 is not given here in this bunch, but your lordship has that book.
Yes.
It's got a 2016 rules, which says for a private owner of a lease to even negotiate with him and give it to him, everything is covered by prior permission and authorization. He can't. And this is true of minerals other than hydrocarbons and atomic. In hydrocarbon and atomic, of course, there's no question. It is already gone with the state. But for all other minerals, every other mineral. So, Manas, it is a relic. It's an argument used to decide the main matter where 99% leases are not there and lordship is, it is true factually. I can't deny it. But Manas, it just doesn't make sense to interpret it on that basis, my humble submission. Now, Manas, that's the 2 points. And lastly, Manas, as I finish my first proposition, just see that 4 months later judgment by the same learned judge who presided over India Cements and how he understood tax. Kindly see the Honorable Chief Justice in volume 5I, page 67. Starts at 65, at 67. He presided over India Cement. The learned judge who presided over India Cement, 4 months later in a former bench. Oh, come on, give it now, give it.
Just that.
5I? 5I starts at 65, relevant at 67, para 6. And well, I will always hearken back to that question. What is so specially wrong about India Cements? Or what is so specially correct about Kesharam?
Which part is that?
Para 6 at page 67. That this entire established law should be changed. I'm sorry, not 4 months, 2 months after India Cements. 2 months after India Cements. Well, the Chief Justice, as he then was, says, we do not find much substance in this contention. Does my Lord have para 6?
Yes.
Recently, a constitution bench of this court has held in India Cement. Recently is 2 months earlier. That the royalty levied on the extracted mineral was the nature of a tax and not in nature of a fee, which could be used only for specific purpose. Any tax realized, etc., consolidated fund of India. I'm not reading, but it's to save time. Well, all this is happening because a 5-judge bench, at least judicially, Malas, has set the cat amongst the pigeons. Unless there's some overwhelming reason why a lordship should not follow a 5-judge bench. Malas. Otherwise, the law was very clear, understood as clear. Malas, coming to my second proposition, I must race along, Malas. Dead rent is the second proposition. At page 335, it starts. Is clearly even a fortiori a tax. As your lordship knows, the scheme is central government occupies in 9 the royalty. In 9A, it starts occupying the dead rent. But I would like to call a dead rent an idling charge.
It is made to the government. Will a minimum guarantee payment also be partake the character of a tax? Because in a large number of situations,
Yes.
a minimum guarantee payment is assured to the government, whether it's an electricity company.
Answer
Because
is
the
simple.
principle is you must lift
No,
electricity.
answer is very simple. I appreciate my lord's question. It's very important. Nobody can say a minimum guarantee.
Suppose there's a public-private partnership. Government has wants an assurance of a minimum revenue.
Straight
It
away.
says this is, you must give me this, irrespective of what profits you make.
Straight away, Malas, straight away. There's no problem. Every example which your lordship has in mind will be contractual. Every example. What are these public PPPs, Malas? One is a BOT highway. Second is a tender. Third is an auction. All contractual. This is, Malas, an exaction under 9A. Your lordship has a clear dividing line and I'm not going to be inconsistent, Malas. I've just yet to show a lordship a very interesting statement of objects and reasons when 9A was brought in. Your lordship will be shocked. Every case will fall in the contractual versus the non-contractual exaction line. And that's why 366/28 is perfect. Chief Justice Latham is perfect in Chickering. Followed by Malas, 1 9 judge and 1 7 judge in India. Shirur Math and Jindal. Now in this Malas dead rent, first of all, the points are the same, Malas. 3 elements: compulsory, non-voluntary, exaction, and Malas enforceability. Same. Here the additional point is, it is not based on what you extract.
Nature of a tax.
As a matter of fact, the better way of looking at dead rent is it's a charge on you taxation for squatting or for Malas idling. You just idle. Either Malas, my learned friend Tushar Mehta gave a reverse example. I would think the better example is that you sit and do nothing. He gave an example that you overexploit early. Suppose you do nothing. You are depriving this man from getting it. You are not contributing to the country and you're sitting idling. So dead rent comes in, irrespective of whether you extract or not. Now, Malas, in this, P31 straight away is extremely important. Well, this also was in Form K. It was transposed from Form K in 1972 and put in the section. This is apropos the Honorable Chief Justice, very important query. Of course, according to me, it was statutory even in Form K. There was no doubt about it. But after 1972, the issue vanishes. It is made a special statutory provision with a capital A. That's my para 31, B31. Now, in 72, they brought in two sections together, 4 capital A and 9 capital A. I hope I'm clear with this. And the object, the SOR of 4A, which I am reading from the note itself rather than taking your lordship to save time, is very, very, very interesting because it replicates the language of 54. It reads, so as to enable mineral development of that area by a government, company or corporation. This is, lordship will get in volume 4, 915 and 916, but don't go to it. It will save time, it's quoted by me here. Well, 4A and 9A are related. 4A is lapsing. And for if you don't, if you abandon the mine, lapsing. And 9A is squatting or idling. Similar concepts. This is the object. This is the object. So, I think I've done my second issue, ending on B32. Hence, there can be no manner of doubt that 9 capital A was introduced to further mineral development in nature of a tax on mineral rights, thus qualifying for the limitation, etc., etc. I turn to my third proposition, which I use the very loose, and I said so myself, incorrect analogy. Look back. There is a phrase in private international law with that French word renvoi, which is look back. It's like a circle. You come like this, you come here, you reach here, and you look back. Whereas 50 is a very interesting way of looking at 50. It's a look back provision. And let me accept. This my third proposition is the entry 97, read with 54 proposition. Let me explain that and then I'll read the paras. Let me explain that first. Let me just explain that, fellas. Entry 50A, I'm breaking it up now, and Lordship has seen the language many times. And your Lordship, very important to note the opening 3 words, taxes on. That has been given less weight. The provision is focused on taxes. Now, when a provision opens with taxes and then follows with the word limitation, it has to contemplate limitation on taxes or qua taxes. Otherwise, the provision is meaningless. It will read very distortedly. Taxes on mineral rights, then of course subject to limitations, etc., etc. So the limitations. So point number 1, it is on taxes. Point number 2, it looks back to limitations of inter alia qua taxes by a superior provision. Entry 54 is the only superior provision. There is no other provision. Third, once it looks back to 54 and taxes are the subject matter, then 97 can't be ignored. Because you have to read 54 synergically. I am not reading 97 as standalone. 97 has no value standalone. But once 50 is looking you back into 54, then 54 and 97 must be read synergically. Because the whole of list 1 specifically put those words in 97. That when you don't find a specific word in my list, in list 1, then you must use 97. Now, to that, the Honorable Chief Justice asked many times, what about 248.2? 248.2 says, provided there is nothing in list 2. Answer is very simple, brothers. I am now addressing your Lordship's 248.2. Answer is simple. If list 2 was a vanilla provision of taxes on so and so, then 248.2 will bar my argument. But entry 50 is not a vanilla entry. It's a unique entry which says, I am myself subject to a superior power of 54 and 97. So 248.2 is satisfied fully in my favor. 248.2 protects a vanilla entry of a taxation in list 2. But if there's taxes on mineral rights, full stop, then I could not make this argument.
The only problem, Dr. Singhvi, is this. If you look at entry 97 just as it stands, you see, what you are arguing, there's obviously, it's a weighty point, that once there's a limitation on
Nine judges
entry,
have the advantage of us making all kinds of fellows because the lordship is a creative. They say no tabula rasa. Lordships can decide whatever fellows is.
because, entry 50 speaks of limitations.
Yes.
Now, if you are right, for that purpose, we have proceeded on the basis that you are right,
Yes.
to test the hypothesis, that the limitation is provided by the MMDR Act. Once the limitation is provided by the MMDR Act, then the power of the state to impose a tax on mineral rights under entry 50 is denuded, right? Is denuded. If that power is denuded, your submission is that power to impose a tax on mineral rights has to be located somewhere. And if it is to be located somewhere, it is in entry 97.
54 read with 97. That's important.
54 read with 97.
Because otherwise your lordship will be right. I mean, I don't want to have a standalone situation. The basic power 97 was meant to go with
54 does not. Entry 54 does not cover the field of a tax at all. Right? The power then to impose a tax, it's actually, I'm incorrect because the lists don't confer a power. 245, 246 confer a power. But the subject of a tax, which does not fall within entry 50 then, or which is subject to a limitation under 50 by your submission,
Let me answer that.
has to go to entry 97. The problem with that argument is that entry 97 says, including any
other
tax
matter
not mentioned in either of those lists.
Including any tax.
Even if there is a limitation, even if there's a limitation imposed under entry 54 of list 1,
Yes.
that tax does not cease to be a tax mentioned in any of the lists.
No, may I answer straight?
The tax still continues to be mentioned in all
well,
of the
there's
lists.
a slight thing. I appreciate it. Allow me. I understand my laws completely.
Right, therefore,
97
that the power of the state to impose a tax is subject to limitations.
97 disapplies itself because mention is made in 50 is what your lordship is saying.
Otherwise, look at it slightly differently.
Yes.
Here, according to you, the states cannot impose a tax on royalty at all because of the MMDR Act, which covers the field, right? Because that's a limitation. Suppose, for instance, the parliament has imposed a limitation not of this nature, which according to you is absolute. The states cannot impose a tax on royalty at all, according to you. Suppose parliament imposes a limitation short of an absolute limitation, right? It, in other words, permits the states to impose a tax on mineral rights, but hedged in by condition 1, 2, on atomic minerals not exceeding 5%, on bauxite not exceeding 7%, on XYZ not in minor minerals. In which case, it could well be argued that Parliament then retains the power to tax mineral rights bereft of the limitations which it imposed on the states. That can never be.
I understand my law's query. Allow me to answer. It's very important. The nub of this.
Entry 97. Entry 97 was introduced because the framers felt, when they framed the constitution, that in future, there may be new taxes which we never knew of. They may not have contemplated those taxes. And exactly, service tax was goods and services tax.
Answer that. It's very
GST was not mentioned anywhere at all.
I was now applied squarely to this case. First of all, let's just keep MMDR aside for a while. I'm at one stage anterior. The simpler argument is 9A, 9A, 9B and 9C occupy the field completely. That occupation will be provided Parliament has the power to occupy. So I am going one stage before, against myself. 9A, your lordship will just leave aside 9A, 9B. Now your lordship, as the Honorable Chief Justice, the heart of the query is that 97 says not mentioned, clearly 50 mentions, therefore 97 disapplies itself. I understand the query completely. Now, what is my answer to this? We have to start the sequence again and give me just a couple of minutes, very important, but conceptually. Entry 50 deals with many elements, but two crucial elements for this argument, taxes and limited by law relating to mineral development. Now I'm only answering my Lord's query. I'm not going to the larger issues. 50 does two ingredients vital for my answer to my Lords. One, taxes. Two, limitations imposed by law relating to mineral development. It can't be a limitation relating to non-mineral development. Clear, Manas? Number 3. If 50 makes itself a non-vanilla provision, not saying taxes on mineral rights, full stop. But 50 itself says taxes subject to a limitation by law related to mineral development. The third step is, which is the only source of power for mineral development? Answer has to be 54. That's step 3. I'm breaking it up. Allow me to just develop this. It has to be 54. That's the only single source of that subject. Number 4. Having reached there, you are in actually only one situation, because it doesn't, 54 doesn't use the word tax. So why do you find, that's why 97 was created. If Parliament makes a law limiting mineral, relating to mineral development, which is a limitation, the taxing powers goes concomitantly with 97. Now the fifth point is important. The word mention in 97 is not to be read literally to mean if there's any mention. What nature of mention is there? What is the architecture of that mention? What is the form of that mention? What is the way you have mentioned it? Your Lordship's word mention would be correct if it said tax on mineral rights, full stop. That's the mention which will disable 97.
So you're saying 97 has to be read harmoniously with 50.
First and foremost, yes. First and foremost, 50 has to be read harmoniously. 54, then through 54, that's what my Lord said just now. Well, is the mention word, I understand what my Lord is saying. It's,
That is the
that's
point.
the crux of the matter. That's why I divided it into 5 points. The answer is divided into 5 sub-points.
There's something in what you're arguing for this reason, that it can't be in the contemplation of the Constitution that then nobody can impose a tax.
Exactly.
Right?
Can't be a vacuum.
There can't be a vacuum in taxation as there can't be a vacuum in legislation. On the one hand, because of a central law, the states can't impose a tax because it's a limitation. Then does that mean that even Parliament cannot impose a tax? I mean, there is a point which we'll
That is,
on that.
of course, well, if your Lordship holds it to be a different kind of entry 50 than what we are saying, then the matter is different. Your Lordship has to consider this part of the case, which is that 50 is a very unique entry. It is clearly looking back at 54.
Which also then leads us to one more question.
Yes.
All those levies which Parliament has now imposed under the MMDR Act,
Yes.
nobody's challenging those levies, of course.
No, they've been challenged
Somewhere else.
Ah.
But under what power did Parliament impose those levies?
No, it is 54 and 97. Ultimately, no, now judgment is said so. Problem is Keshoram. Mahalakshmi said exactly what I'm saying. The problem is, Keshoram came along and ignored number of judgments, including Mahalakshmi. I would like to claim Mala's novelty and ingenuity. I can't. Mahalakshmi has much of this. Keshoram, with respect, could not have set the cat amongst the pigeons on this basis, Malas. I've quoted Mahalakshmi. Allow me to read that. Malas, Honorable Chief Justice will kindly allow me. This is a very important question dealt with by our Lordships directly. It is only Mahalakshmi which is a dissonant voice. My Lord has been consistent. Let me give you those 4 or 5 cases in a minute. So now, Malas, I'll be reading now from 11 onwards very quickly. This is the whole case. Now, Malas, on this point, these paras will show Lordships that I am not able to claim ingenuity or novelty. This has been
You're
done before.
proceeding on the basis that royalty is a tax.
Yes, that's a set of arguments.
Yes, suppose there's another perception.
Yes.
If royalty is not a tax, of course, in the subsequent judgment, they said it is akin to a tax.
Yes.
It is an exaction, but not a tax. Then what would be your argument?
First of all, akin will not make a difference, but 36628 will make it. But let's forget that argument. Yes.
It is under the grant of a lease.
Yeah.
It is for exercise of a mineral right.
Yes.
But it is not a tax.
Yeah.
Then what would be the argument? The state's power under entry 50 remains. while under the parliament,
Why-
royalty may be
That is
imposed.
why I said that would be, Malaz, a acceptance of Mr. Dwivedi's argument and a repulsion of Mr. Salve's first part of the argument. But Malaz, in my case, even then, dead rent is not answered in my lord's query. What about dead rent, Malaz?
India,
Remain a tax.
in India Cements, they included the word
No,
royalty.
dead rent is, sorry, go.
In India Cements, the problem arose because they included the word royalty in the definition of that particular impost or cess.
Malaz, with respect, Malaz, I'll read those two paragraphs. Mr. Ganguly will read that also. Straight away. Para 34, India Cements is not. Allow me to answer. No, straight away. Yes. Malaz,
Definition.
may I say, India Cement, independently on first principle, holds royalty to be tax. Directly and clearly, not because it's included here or there. Then it says, cess is another kind of tax.
Yes.
Therefore, tax on tax is bad. But royalty is a tax is independently on first principles held by India
It
Cement.
stems from the fact that the word royalty was included in the definition
No, Malaz.
Yes.
Respect, no. I'll show that.
of the State Act.
Malaz, it will make no difference. Malaz, obviously, a tax of any kind will have to have some statutory basis.
Yes.
Under Article 265, your lordship cannot have. So it has to have some backing. But the basis is therefore statutory in the, not the strict sense, but let me say sovereign levy, exaction and enforceability. Your lordships cannot have a tax. Well, suppose I contractually demand something, it won't be a tax. So that much will be there always. But India Cements is directly holding it to be a tax. It is holding it because, well, it is an exaction. Of course, they had a separate question. The first para puts it that is this cess on royalty valid? So cess on royalty makes it worse. It's already a tax. On that you put another tax. So that's the issue. But to come back to this, dead rent is a good example because dead rent is a for sure a tax. Tax, Malaz, dead rent is a for sure a tax because it's an idling charge. You do nothing, you still pay it. It's a compulsory, it's exactable, it's enforceable, no option.
Dead rent is a tax. Dead rent is also very intrinsically related to royalty. That's why the proviso to section 9A1
Yes.
says that when the holder of a mining lease becomes liable to pay royalty,
Yes.
he shall pay either royalty or dead rent, whichever is higher. So it is really
No,
to the
but-
nature of it's for the exercise
me answer.
and therefore non-exercise of the mining
Well,
right.
let me answer that with
It's
respect.
relatable, it's relatable to the exercise of a mining right. Dead rent, your concept
with respect,
that this is
Manoj.
a tax may not be correct.
It is no, Malaz, with respect. It's conceptually the very same point I'm making. It has to be related to royalty because if you mine and extract, you will pay royalty.
Now,
If you don't mine and extract, you are squatting, which is why you pay dead rent. It's an idling charge. I started by
it's not
saying
a
that.
tax.
Well, just see.
It's a charge which you pay to the state
Yeah.
for not having exercised your right to extract, and therefore the state is losing revenue.
It's not optional.
And therefore you have to pay.
It is, so what is that's why Malaz 3620, impost. What characteristic of a compulsory levy does it not have? It's compulsory, it's 9A, it can be enforced by 25. The man can't, and the rate can be changed by amendment to the third schedule. Your lordships can't change the rate without amending the third schedule. It is completely a tax, Malaz. And the whole idea of putting 36628 was to catch those minor creases which said that no, it's not a tax in a full form called so. Well, your lordships can't change the rate except a third schedule amendment. And 25, same recovery procedure. So,
9B5, which is the District Mineral Foundation, and 9C4, which is the National Mineral
No.
Exploration Trust. This is all paid as a component of royalty.
no, with respect, well, it is alternative.
Instead of passing this 9B and 9C,
Yeah.
they could have just enhanced the rates of royalty. They
No,
put an
no,
additional provision. That's all.
Let me explain.
It doesn't
Whereas
cease to have that
9
connect with royalty.
9,
Yes.
9A, 9B are all taxes.
And doctrine
9C
above
can be a
everything
fee.
else, assuming royalty is a tax,
Yes.
where is the bar on the states imposing a tax on mineral rights? Because it's still in the nature.
That's my fourth proposition. That's coming. That's my fourth proposition.
There's no bar on the.
I am conceding. Let me, shock your lordship by saying my fourth proposition, say I concede that. But you're not levying a tax on mineral rights. For a minute, Wallace, for the purpose of argument, let me concede that you have a right to, I'm not accepting anything, Wallace. Concede the fact that you have a right to levy tax on mineral rights. Allow me, that's my fourth proposition coming up. But let me finish my third, Wallace. My third proposition therefore rests with 9, 9A and 9B. Kindly read them carefully.
So what is the proposition in section 9?
This is my proposition number 3, Wallace, at my first page, 320.
How do you formulate it?
Yeah.
9,
9A, 9B.
Yes.
Are taxes because they are compulsory imposts by a public authority enforceable by coercive measures, bracket e.g. land revenue, etc. And are changeable only by statutory amendment. There is nothing else a tax has, brothers. No tax will have anything except this. No tax. Otherwise, the whole concept of tax will change. And if 7 judges in India have held so, why should a lordship depart unless there's something fundamentally wrong? This was accepted by India 7 in so many cases. It's just that Kesharam has created this new thing. 9C is, however, a fee because there is a quid pro quo of exploration. I myself said so in my note. 9C has an element of quid pro quo and is a fee. It's an exploration issue. Third point, Wallace, apropos the Honorable Chief Justice's query. Two more sentences on this, Oliver. 9A, which is dead rent, has to be alternative. Because when you don't mine the land and extract minerals and squat or waste time or sit there idling, then dead rent comes in. So the very concept is in the alternative. That's the concept of it. The whole idea is that you must mine.
All right, there's a third point now.
And the last is that some of these calculations in one or two of these cases is done by a percentage of the royalty. That's a calculation. That has nothing to do with changing the character. It says that you will pay at X percent of the royalty. This first completes my third point, but the most important part of the third point is the look-back nature, non-vanilla nature of entry 50. I've done proposition 3 minutes. Proposition 4 is what my Lord, the Chief Justice just now asked me. No, I'm sorry, Malas, I have not finished. I have to read very quickly this previous point. Please turn to A11, Malas, page 310. I was conceptualizing it. I have not. This will be very quick. I'll just read it very quickly. On the previous point, Malas, that is on this 50 look back and 97. Come to Malas para A11 at page 310. This I had to read, Malas. Extremely important. Such important judgments are completely, Malas, put to the side by Kesharam. That's the only reason, Malas, your lordships have to exert. Please turn to, Malas, page 310. Does my lord have it? All my lords have got it? Yeah. Now just, I will read the bold face only, Malas. I'm skipping. This is Mahalakshmi. Once the parliament has occupied the field in connection with regulation of mines and minerals development, and when the parliament declares it is expedient in the public interest to do so, entry 23 of the state list regarding regulation of mines and minerals would be of no avail to the state legislature, as entry 23 is subject to list 1. Nor will entry 50 be of any assistance in this case. Kindly go further, the bold portion. Once these entries are out of the picture, it is entry 54 in the union list which will operate, and the imposition of tax on minerals extracted would be squarely covered by 54. Now come to the next page. Section 9 being part and parcel thereof cannot be out of the sweep of 54. However, even assuming that there should be a specific taxing entry regarding taxing of royalty on mineral rights, which can sustain such legislation under the said entry, being a topic of legislative power. We find that there is no such specific entry in union list, nor in state list or concurrent list, which can be of any assistance in this connection. Entry 50 in the state list is out of the picture. That's non-vanilla entry. Then, Malas, in the alternative imposition of such hybrid tax on mines, on capital, on labor, would be covered by the residuary entry 97 of the union list, which empowers the parliament to enact laws on topics not covered. Now go further, Malas. It is not a flash in the pan. It is not, Malas, one solo which I want to make a summer out of. Come to, Malas, the next judgment, Saurashtra. Yes, that's it. Now, no, that's a no, I'm going to cite it. Now, the next para is Saurashtra. This is not that Saurashtra. This is the Supreme Court Saurashtra. Yes. The other one was the Gujarat High Court. The boldface. Section 9 and 9(3) thereof, by holding that by entry 54 of list 1, it was within the legislative competence to make the law in question. Neither 23 of list 2 nor 50 of list 2 would be attracted. It is no doubt true that in the aforesaid case, that is Mahalakshmi, aforesaid case, the court also held that 97 will confer legislative competence, but not because Parliament has no competence under entry 54. They went further. 54 is enough. But it was used as an additional prop. I hope I'm clear, Malas. They say 54 is enough. 97 is an additional prop. Now, Malas, come to A15. Kannadasan, I'm not citing, Malas, Mr. Salve was dismissive of it. I'm not citing for that purpose at all. I am citing that when your lordships had so much collections and you had to help the states to not get refund, you passed Kannadasan. You passed the Validation Act, and it came for Kannada. Look at these highlighted paragraphs. Sri Sanghi argued that the denudation is not absolute, but only to the extent provided in the MMDR. Section 9, Learned Counsel submitted one of the facets of the extent of denudation. This partly will deal with the extent argument also. This contention assumes that notwithstanding the declaration in 2, the states still retain the power to levy taxes upon minerals over and above those prescribed by the MMDR, and that a fresh declaration is called for whenever such subsisting power is sought to be further encroached upon. That was the original argument. Each time you must have a fresh declaration. Then 313, page 313, the denudation is not partial, it is total. They cannot levy any tax or cess on minerals so long as the declaration in section, there's a misprint there, 2 stands, 2 is missing. Once the denudation is total, there is no occasion or necessity for any further declaration or, for that matter, for repeated declaration or denudation. Now, Malas, let me make the submission after I finish. Come to para 17. Even assuming without conceding that the declaration in 2 does not ipso facto oust the state's legislative competence, I'm arguing the alternative, expressly contemplates the levy of taxes thereunder as evident from section 25. And the fact that it levies a royalty, which is a special kind of tax under 9, and a dead rent under 9A, denudes the states. Conclusion in 18 is very important. Conclusion. Thus, even assuming entry 50 is to be read restrictively so as to require an inquiry as to whether any specific provision imposes a tax. 9(1) imposes tax, directly covers the field. 9A imposes dead rent, directly covers. 9B imposes a cess to be employed for upliftment of the district affected. I'm on the next page, Manas. And Manas, your lordship will just allow me, this Pradhan Mantri Khanij Kshetra Kalyan Yojana, which is at page 47, is very useful. It'll repay study. I don't have the time to show it. Please make a note and please see it, Manas, at your lordships. The center covers the entire gamut and tells you how to use the money till the last user. This Pradhan Mantri Yojana, Manas, is page 57, is very comprehensive. And it is issued under section 20 capital A of the Act. So Manas, here one sentence. This extent will not have any problem here because coverage is complete. The coverage cannot mean multiple piecemeal legislations. I gave the example of the coat and the gown and the band yesterday. You cannot have multiple legislations that because I covered the coat and the gown, tomorrow, Manas, somebody can do on shoes. That, Manas, its intention is to leave that to the center and not tax it. There is an implied prohibition there clearly. Then, Manas, para 19. Now, let's just see. Odisha Cement says, all these are ignored, brothers. I mean, not ignored, they're just brushed aside, cited and brushed aside. The object of 9 cannot be ignored. 25 implicitly authorizes the levy of rent, royalty, taxes and fees, directly the issue. But if your lordship total the number of judges who are spread over India Cement, Odisha, synthetics is coming. So all judges have the same view. I mean, your lordship is of course plenary. But why should your lordship give so much weight to Kesharan? This is the only dissonant judgment. Now see the next one. Synthetics is very interesting. My lord is hearing synthetics from the other point of entry 3 list, entry 33 list 3. This is a different point, very interesting. 7 judges are held so. 9 or 7? 7. Now see, Mahanadi. So Odisha I have done in 19. Now see 20. 20 is Mahanadi. A perusal of the MMDR, all the sections are given, will clearly point out that taxation on mineral and mineral rights, any tax, royalty, fee or rent are provided in the said act. The state legislature is denuded or deprived of the power to enact. Then 21. Well, these are calculations I've given. Your lordship may just keep it in mind. I will save time by not reading it. I'm only adding to Mr. Tushar Mehta as well as impassioned plea about various monies where they go. The last part of para 21 is very interesting. He's given you the details. I don't have to go. That's the government's job. But just see, all these total to about 16 to 21% of the average sale price. Last line, above para C. Above para C, my lord has got. All my lords have got the line above C. Total of all these levies, which is 9, 9A, 9B, 9C. Of this 21 or 16%, 0.3% is retained by the center. The previous line above that. That is 2% of royalty NMET. That is 0.3%. All the rest goes back. Now let's see next para C at page 315. Most significantly, all these levies except NMET, that is 0.3, admittedly go to the state government coffers. Then state-wise breakup is given. Mr. Mehta has dealt with it. I'm not going to deal with it. 2 more para that I'm done with this part. 23 at page 316. Now, it is true that the general standard Sundarama Iyer concept of grouping is there. Before I read it, my answer is simple. That is not a mechanical sorting machine. Where this article leads you, lordship, to think differently, that is 50 special unique architecture, then that grouping is not cast in stone. That's my submission in 2 paras. Sundarama Iyer is valid, but it says itself, it's not exhaustive. Sundarama Iyer, that judgment which says grouping, says itself that don't treat it as exhaustive. There may be entries like 50 which don't allow grouping because they're uniquely worded. My Lord if I may say, called it 8 mantras, Honorable Chief Justice 2 days ago. I've dealt with that. Let's kindly come to 823. You have to, therefore, not be a slotting machine. You have to go entry-wise. Mostly, Sundarama may apply. Sometimes will not apply. Your lordship's analysis or interpretation can't be straight-jacketed by a Sundaramaya focus that no, I have to group. This is a unique architecture. This one is not a grouping architecture. It is 54, 97, 50. It's a totally different triangle. Now come to verse 23. For these reasons, 50 and 54 read with 97 imply a sui generis and complete code on regulation of mines and mineral development and taxation of minerals and mineral rights, as the state's power of taxation in entry 50 as well as general powers are both subject. Both is italicized. Then let's come to 24. 26. I'll skip 24 to save time. Come to 26 straight away. This is, the word mantra is replaced by the word sutra here. The Roy's case from Assam acknowledged that the scheme of the 7th schedule cannot be governed by a straitjacket. Our endeavor is, because he goes against the Guire principle. The Guire principle is grouping. So he says, no, it can't be a straitjacket every time. Our endeavor is only to demonstrate a great deal of examination, etc. No rule which has a universal application with regard to the interpretation of all entries can be postulated. That's my point. That's my respectful submission. The statement of Justice Guire, Chief Justice Guire, that a broad and liberal spirit should inspire and the legislative entries should not be read in narrow, cannot be understood as a sutra valid for all times and in all circumstances. That's the only point I want to say, Malas. And Malas, para 26, next page 318, I have mentioned 8 mantras, 8 formulations which the Honorable Chief Justice done. I am now coming to 27, which is a little noticed, but an extremely important paragraph, A27. 7 judges in below synthetics, not on the point your lordship is considering next week, say the power to levy taxes is to be read from the entry relating to taxes and not from the general entry. Exception in entry 50 of list 2 where tax on mineral rights is subject to any limitation imposed by parliament relating to mineral development. And this power of parliament is in general entry. There can be no more direct than this for us. Now, you may say, Malas, the 9 judges is wrong or right, but certainly Malas Kesharam, with greatest respect, had no business to Malas brush it aside. Then Malas,
The power to impose a limitation has to be read under entry 54. That doesn't mean the power to impose a tax is to be read under 54, read with entry 97.
2 answers, Malas. It means a tax because of the language of 50. That's the opening word of 50. 50 cannot contemplate a limitation which cannot be a tax limitation. Answer number 1. Answer number 2. 7 judges have said exactly what I've said just now.
No, it's a limitation on the power to impose tax.
No, tax it says. Synthetic says tax.
Yes, the limitation on the power to impose tax.
Yes.
Means the power resides with the state. The limitation emanates from entry 54.
Yes.
Correct.
Therefore, the power resides in the center also, Malas. The center cannot impose without all the power, Malas. The power has to be in the center, Malas. And a superior power is the center.
I'm trying to say
Yes.
is the power to impose a limitation doesn't take within itself the power to impose a tax.
Malas, with respect, let me examine. That's a new nuance, my lord. Give me 2 minutes. Malas, how do you limit a tax without reducing or imposing? Suppose the state imposes 1%. I want to limit it, I say abolish it. Your lordship has to assume that I have the power. If the center has no power, the matter ends. Your lordship will not be able to control it. Limitation has to include from 0 to 100.
Can say, we are abolishing the power of the states to levy the tax.
Yeah.
But we are going to levy the tax. That's not the scheme of the constitution.
By 97, they will have the power. If your lordship resides the power, it has to have the power. With respect, Malas, with respect, that will be an artificial limitation. No, Malas, let me just explain.
Very
Let
clearly,
me explain, Malas.
it is very clearly divided, Dr. Singhvi.
Yes.
The state is given the power to levy the tax.
Subject to limitations.
Subject to limitation, we understand that. And we go into the limitation of 54. But you are trying to bring in 97 as also a power to levy tax. How can the residuary entry be utilized for this purpose?
Can I? First question to be decided is, does the center have the power or not? Matter ends if your lordship finds they have no power on taxation. That's the primary question. All this debate is if they have some power of taxation. My answer is they have to have a power of taxation because the limitation envisaged and recognized by 50 itself is a limitation on taxation. 50 itself recognizes that you, my superior, has the power. We stop here, Malas? Unless we accept the fact that 50 dealing with taxes, using the word limitation, recognizes a superior person, then we can't go further. Now we come to a different nuance, which my Lord Justice Nagratna has asked. Yes, taxation is also within 54 because the look back by 50.
Is in entry 50 list 2. The power to impose a limitation on
Quay taxation.
54.
Right, let's accept that. The power to impose a limitation, quay taxes. We are only considering that, right, Malas? Now, my 2 submissions there are, if your lordship concede, this is only a debate, your lordship doesn't have to concede or accept, your lordship decide. But if your lordship accepts a power, that taxes can be limited by the central government under 54, then 2 facets. 1, the word limited by central government has to include the plenary power from 0 to 100 is the first submission. It's not that your lordship gives him some power and not gives him some power. He either has the power or doesn't have the power. On taxes. And I say he has to have the power on taxes because 50 looks back. Now the second facet. Once he has the power, I am only
Back
using,
to limitation.
Yes.
but limitations quite taxes, because the entry is on
It
taxes.
does not transfer, the limitations do not transfer the entire field of taxes on mineral rights to Parliament under entry under list one.
No, if Parliament chooses not to do so, yes. But it's kindly go to 50.
Because
Let's go to
you know the danger, look at the grave danger to the Indian federal structure by accepting your argument.
No, Parliament can decide not
Suppose
to play.
Parliament prevents, suppose the limitation assumes the character of a prohibition. Because there are judgments that say a limitation can amount to a prohibition. Then, on the one hand, Parliament can prohibit the states, but it can say, I have prohibited the states, so now the entire field is left to me.
There's a little
Under
difference.
list one. Point number two, Parliament imposes limitations. It can say, I have limited the states, but I am unlimited.
Can I
I
answer?
can impose a tax minus those limitations.
Can I answer?
That was never the.
Can I answer
That
this?
was never the intent.
Can I answer that?
And appropriate what the Chief Justice was saying, you see, merely because bulk of the revenue collected goes back to the state would not meet the argument that the
That's a
Chief Justice.
constitutional argument. This is a factual argument. There are two different things. I'm not, one is your lordship first has to locate the power. This is not a question of fact whether I give you back or not. That's not, I'm not arguing that.
The limitation in on mineral development.
No, therefore, now let's just look at 50 for a minute. Just look at 50. I know this is too late in the day to look at 50, but let me give you lordship 1 minute. Taxes.
आमची power आहे. The next
Yes, very well,
topic
very
now.
well. Only one sentence and I'm done. I've made my submissions here. Lordship may or may not. I'll go to the next point. I only want to say one thing.
Argument of looking back, Dr. Singhi.
Yes, yes.
It might be seen by the states as looking back with anger, you know.
Super hit it was, Willis. Now, Willis, one sentence and I'm done. I'm going to the next point. I'm coming to my next proposition with one sentence in the last one. There are therefore, in summary, 5 judgments. What should be note on the side is not in my note. 3 of them locate this point in 54, read with 97. I'm summarizing now. Those 3 are Mahalakshmi, Saurashtra, and Justice Sinha dissent in Kesharam.
Just one. There are 5 judgments. We locate the power of Parliament to levy a tax.
Yes. Under
On
54, read with 97.
And you have given those as Mahalakshmi.
First is Mahalakshmi, then is Saurashtra.
Then Sinhaji's dissent in.
And the 4th is important, Odisha, which is quoted in my page 311. I'm saving time, it's a very useful quotation. 4 judgments. I'm sorry, that 4th one is, I'm sorry, that's an error. Justice Oza in India Cement, I meant, not Odisha. Justice Oza in India Cement.
Not Kesaram.
Not Odisha. No. Justice
Oza in India.
Kesharam and Justice Oza, because he was a concurrence fellows, in India Cement.
Yes, we saw that, I remember.
And there is one more judgment which does the same conclusion without 97. Without 97, which is Mahanadi plus synthetics. 2 judgments, I'm sorry, 2 judgments.
Mahanadi.
And synthetics. They're all quoted. So my lords has 6 judgments in all, 4 which do conjointly 54 and 97, and 2 which rely on 54, but the same conclusion, taxation. My question remains the same to myself, Willis. Why should Kesharam be preferred? just winding up. Interested in 10 minutes more. This is an important proposition for your lordships to lay down guidelines. It is dealt with from 319 to 322. 3 pages only. Let me make the point, then your lordship doesn't have to spend time on it. I only want to ask your lordships, again without prejudice, 3 pages, 319 to 322, that your lordship should make it clear what is the tax on minerals versus what is the tax on mineral rights. My first principal points are twofold, then I'll just read 1 or 2 paras. 50 is advisedly using unique words. I always call it a non-vanilla entry, because no other article in minerals, in Vala's entries, has used tax on mineral rights. 53 and 54 use mineral development. 23 uses regulation of mines and mineral development. 54 uses identical language. Now, Malas, my point is that your lordship should give some weight to that different language used. And one more sentence, factually and contextually. Malas, there's a fundamental difference. One is you tax my extraction from the bowels of the earth. So 10 tons, ad valorem fee, 5%. Whatever the value, sale value, you tax. 100, more tax. It's a fixed ad.
So tax on minerals.
Yes. It's very easily understood.
Tax on minerals.
And in contrast, I give him a lease for 20 years. I give him a lease for 50 years. And I give him a 100-year lease. Or I give Manas different forms of licenses. I don't know all forms the lordship has of them. Along with size. You can tax that, but that's a different taxable event. The nature of the tax is different. I'm not saying you can't tax this. In this argument, I'm conceding, without prejudice argument, naturally, without prejudice argument, I'm assuming that you can tax, but you please tax mineral right. That is the duration and the size which you have to extract minerals, not the actual mineral extraction. The grant can be taxed. This has been held, Balas, incidentally, again, these are all Balas upset because of Kesharam. This has been directly held by 3 persons at least, Balas. The same Justice Oza concurring in India Cement. It's all quoted in my note in these pages. Justice Sinha in Kesharam and Justice Vanchu in Balas in great detail in Hinge. That's the most detailed. I'm going to save time by not reading it. I would request my Lord, those paras repay study. My respectful submission is, what is so conceptually wrong that your lordship should incline to the Kesharam view? Kesharam has cited them all and said, because India Cement had a typo and an error, therefore all these judgments are wrong.
But royalty is not on, is on the mineral removed or consumed.
Exactly.
It is on the
Exactly.
product.
Exactly, that's my point.
But a tax on mineral right is under entry 50.
Correct. So your lordship please lays down.
Say that royalty is not a tax on mineral right, but a tax on the mineral removed or consumed. Then there is no dichotomy at all.
That's all I'm asking for. With the deepest respect, that's my formulation. But I can't say it, your lordship has to say it.
So you are saying that
Nine
if the
judges have to say
states
it.
impose a tax under entry 50, you can tax the grant, but not the extraction of the material. That's your contention.
This is a more pithy formulation. Tax on minerals extracted, dispatched or removed are not part of 53. Not part of 50. And 50, as my lord puts in a different form, I didn't
But
use
it
the
can
word
be
grant.
used as a measure.
You can't. A measure can't change the taxable event. A measure can't change the taxable event.
Taxable event is your right to extract.
Extract, which is not the mineral extracted.
But the state legislature may say, okay, I will impose a tax which will be a certain component of royalty.
Whereas once
Right.
your lordships,
Your right to extract is not really something in the abstract. Your right to extract has meaning because of the commercial exploitation of the right. So the legislature may choose a number of formulations because a number of formulations are open to the legislature. It may say, all right, we will tax at the rate depending on the number of years of the lease. or the quantum of the area,
Yeah.
or the size of the grant.
Yeah.
Or we can also tax on the basis of the actual extraction as a measure of the tax.
Can I Malad, just,
Because that's the commercial use to which you are putting that grant.
no, Malad, my lord is simply putting that the
Say that
measure,
tax on mineral rights should have no connection at all
no, I'm
to
not
the
saying that.
exploitation of the mineral rights. Maybe a little too far-fetched.
Malad,
It's a legislative
Malad,
issue. We
then
must
your lordship would
construe it
be,
in the
Malad,
broadest possible
then your
terms.
lordship would be allowing a camouflage.
It's a field.
No, may I answer that? Your lordship would then be allowing,
And you know, it's not this, that a tax on minerals is given to parliament and a tax on mineral rights is given to the state legislatures. In which case you would have clearly have to restrict taxes on mineral rights by excluding that which is given to parliament
May I
as a
answer
tax
both?
on minerals.
may I answer?
Here, the entire field of mineral rights is given to the state.
May I
And it
answer
is
both the
subject
points?
to limitations which parliament
May
makes.
I answer both the points? Straight away. Point number one.
And regulation and
Point
development.
number one. Well, your lordship will not allow a legislative subterfuge. It's most established principle and axiom of tax law that by camouflaging, you cannot use the measure.
Argument, therefore, Dr. Singhvi, is that, look, you can only tax the right to extract minerals.
Your lordship put it
But
differently.
it must it must have no nexus at all with the actual
So
extraction.
that second point, you're right. I'm saying something else, Willis. Your lordships can let division benches decide the individual case, but your lordships as 9 judges must lay down that what you are given an entry is only mineral rights. Mineral rights can't be equated with minerals, but that will let's say subterfuge. A taxable event can be changed by a measure completely. Now just see, Manas. A grant is well understood. Your lordship taxes, Manas. I mean, in the very minor sense.
Forget this area for a moment. Huh?
Property
Let's go
tax.
back to basic
Property
principles.
tax.
State can levy stamp duties.
Yes.
Well settled principle of law that a stamp duty is never a tax on the transaction, but on the instrument. It's very well settled since independence. Now, all states, including Maharashtra, from where both Brother Oak and I come from, while levying a stamp duty on an agreement to sale, they use the measure of what is the measure which is used? The market value of the property.
I appreciate.
Right.
But does your lordship know clearly the difference? And that,
consistently
but that's the problem.
taxed.
But your lordship clearly knows at that point the clear difference between stamp duty and any other duty.
Now,
Today,
you are right.
excise
You are right.
duty-
We'll have to tell the states. We'll have to tell the states that, look, you can levy a duty only on the instrument and not the transaction. So the underlying market value of the asset which is transferred, you can't use at all as a state
I'm asking
legislator.
myself,
That's barred to you,
if the
sir.
test
We'll have to
laid
tell
down by the
states that.
9,
This can never be.
no, if the
Once
test,
a field is given to the states or to the center, you can choose any numerous formulations the legislature can frame.
the field given is by unique language limited to tax on mineral rights. The field given is not a tax on minerals. Your lordship will not give them a field wider than that is given. And today,
The measure can always be suitably.
measure cannot change the.
The only little caveat is what RR Engineering said, that your measure should not assume the character of the
No,
tax.
I am saying, if your lordships will lay down the guideline, then the division benches will decide in a particular case. But the guideline cannot be that, today you can camouflage a mineral tax, a tax on mineral rights, by levying it on the entire extraction of minerals. That will change the character of the tax. Your lordship has to only lay down the guideline, as two of my lords have formulated. The actual thing will have to be seen act by act. But what is given, this is on the assumption that the states are given something. The states are given a taxing right on mineral rights. They are not given a taxing right on extraction of minerals. Why has entry 50 not used the words of 52, 53, 54 or 23? Is my question to myself. Why has entry 50 used unique words not in 52, 53, 54 and 23? It's as simple as that, Willis. And 9 judges should, referred or not referred is not the point. Today, the lordship should lay down this guideline.
Mr. Singhvi, now your argument comes to this.
Yes.
57 Act does not take away power of the state legislature under 50.
Without prejudice, correct. No. They go on taxing on mineral rights only.
50 is mineral rights, tax on mineral rights.
But the whole question is, what is mineral rights?
No. So therefore your argument is,
Yes.
57 Act does not take away the power of the
No,
state
no,
legislature
assuming
to
that
levy
we are-
taxes on mineral rights.
This is an alternative argument, assuming that we are wrong on the earlier arguments. That you must limit this to mineral rights only. That's obviously a without prejudice alternative argument. If I'm right in the first argument, they have no rights at all.
And therefore your contention is that it should be only a tax on the right to extract.
That's right.
And must be agnostic to the actual extract.
That's all. In whichever way a lordship frames it, grant or whatever.
We can't restrict the
Then
power
well,
of the
the next,
legislature.
we
We can't do it to parliament. Likewise, we cannot do to the state legislatures also.
well, as your lordships in interpreting 50 can
By saying that.
interpret the language of 50 and say so. Clearly. Your lordship would be allowing the grant to be governed by something which happens post-extraction. The language of 50 which you are interpreting is very clear. Please don't allow it to be expanded without prejudice. The fifth and the
Yes.
two last points. The fifth point is at pages 322 to 324, 2 pages. This is settled by 2 constitution benches, Hingir and Tulloch. They are quoted in A47 and A48. It's a very short 2-minute point. Once 23 is denuded, then 66 cannot lie, because 66 is a piggyback provision which lies with 23.
Once
That's-
entry 23 of list 2 is denuded,
Then entry 66 square fees.
entry 66.
Yeah, entry 66 is the entry for fees, list 2.
Oh, the fees. Yes.
Pro tanto gets eclipsed or inoperable or inapplicable. The judgments are clear, Mullahs. My paras, the lordship will note, are 47, 48 and 49 at 322 to 325. They are Hingir, Constitution Bench, Tulloch, and Mullahs, Mr. Sirvai has clearly, very unequivocally in his usual style in A49 of my para. I've quoted that. Said so. Not that Mullahs, any one person is dispositive, but this is Mullahs in the same trend. Now, Mullahs, the last point. Yes, I'm sorry, this should be said. The reason for this fifth point of 66 is para 110 of Keshoram. That will be, Mullahs, with great respect, ridiculously broad. It says all fiscal levies. Then your lordship will have validation of all fiscal levies by whatever name called, including 66 is a fiscal levy. Para 110 of Keshoram says all fiscal levies is clearly overbroad. And your lordship is now laying down the law for. Now lastly, Mullahs, just turn to page 338. This will take exactly 5 minutes. It's a very interesting 10-page analysis of Keshoram. I'll read less than a page and a half. 338. Mullahs, Keshoram with deepest humility and this is grievously wrong. It's not wrong, it's grievously wrong. And why is it so? Again, it doesn't matter. Your lordship is 9 judges, but your lordship should know this because it is really. So first para is C 1.1 at page 338. A point obvious, 5 judges cannot effectively overrule or sideline 7 judges. That's an obvious point. I've cited the case law, not required. That's my para 1.1. They had to refer it. With this kind of surgery, they could not have said 5 judges we are interpreting, we are distinguishing. It's completely changing. Second error at page 339 of my note. The typo point is answered by C.2.2 and 2.3 at 339. Well, I can understand your lordship saying something. With the para quoted by me in C 2.3, how can you say, Malas, that it's India Cement held that royalty is not a tax, and by typo it became a tax? You can say that conceptually I don't agree, I refer to. This will redefine the word typo. That is C 2.2 and 2.3. India Cement is saying with guns blazing categorically. And I've just read a 2-month later judgment by the same person who presided over India Cement, saying that we held that royalty is a tax. Third error
Into a tax.
is C 3.3 at 340. What is the errors I explained in much more detail? I'm only pinpointing 1 or 2 paras each. Well, as it says, and this is where something grievously wrong. It says that India Cements looked at 2 High Court judgments, Mysore and Patna. And then it also looked at 4 other judgments. And India Cements is wrong because it really intended to follow 4 judgments. Now, this is answered very clearly in C 3.3. My lord is ticked. Those 2 judgments are given. 3.3 at page 340. Don't read it. Go to the real relevant parameters. 4.3. India Cement noted 4 lines of cases and 2 lines and said we prefer 2 lines. I hope I am clear on this. That's 4.3. What your lordship prefers is not the point, but Kesharam can't say in 5 judges that India Cement overlooked 4. And why did it choose 2? It cited all the 6. It cited 2 left and 4 right and said we prefer the left. Why can't it say so? And who is Kesharam to say so, Malas? Then, Malas, the 5th error is at 5.2. This, Malas, they say, they brush aside India Cement in Malas Kesharam. I've given the Kesharam paras also. That was, India Cement was a case of cess on royalty. And therefore, there's no occasion to decide royalty is a tax or not. But Malas, that forgets. See, in this year also will only tick 5.2 and 5.5. Only 2 paras. 5.5 is Malas at 343. They were no doubt dealing with a cess. But the para says cess is a tax, royalty is a tax, therefore tax on tax we don't accept. It says clearly the paras are quoted by me.
Now we've seen the matter as
Very
a matter of first
very well.
impression. So
I'm done, Manas.
thank you, Dr.
And
Singh.
lastly, Mr. I'm deeply obliged, Manas. The Lordship will see the written submission for the few things
Yes,
I've
sir.
left out. I'm very
Thank
deeply
you, Dr. Singh. Mr. Ganguly.
I'm very deeply obliged for your
Thank you.
cooperation and time also.
Yes, Mr. Ganguly.
Should have.
The parties I've appeared for, I've given here.
May I please lodge this word? Lord, I beg to appear primarily for one of the PSUs for the coal producers, as well as MCL. I've given the respondent number 8 and all the numbers are given. Lord, I have given my written submission to the first trench of our submissions. I don't want to.
Well, can you just give us
It's
a
in volume
reference?
2.
Volume 2.
Volume 2, pages 4 to 44. Lord, I beseech your lordships to kindly allow me not to read them, but I'll treat them as read so that your lordships will have it, the text before you and you know what I did. So I'd be in view of the paucity of time, because your lordships have rationed their time. So in view of the paucity, I would try to be as brief as possible, making only the essential points. So very briefly, without going into my submissions right now, detail. First and foremost, your lordships have had enough of argument on both sides as to what is the scope of interpretation of the relevant entries. I would not go deep into it, except what I have to say at the beginning, with others I will not be in a position to develop my argument. 50 lordships have seen, we are only on 50 now.
Just give us the volume so that we just have a look at which one.
Volume 2, my submissions are in volume 2, my lord, page 4 to 44.
7 actually starts. The index.
That came in your earliest volume.
Yes. It's actually PDF page 7, I think. Yes.
Oh, I'm sorry, my lord.
No, we have got it now.
No. This is my first one. And their second set of submissions, my lord, with reference to the particular coal mines, that your lordship will get, my lord, in volume 2G, page 21. These are the two sets of submissions. Volume 2, my lord, is the first one, and 2G is the second, which is with reference to the Coal Bearing Areas Act.
Right?
No, I'm not reading.
Oh, then it's okay.
No, I'm not.
Then you can just formulate it.
I just
Then you can just.
give a reference, so that your lordships can read at your convenient time. But briefly, I'll just keep my summaries, my submissions. Your lordships have heard for so many days the scope of the various entries. First proposition, that a law made by Parliament under NT 54 subsumes the entire subject matter under NT 23 of List 2. There is no doubt. On that, there is no caveat. It is accepted. Because they are the same subject matter dealing with the law, and 54 undoubtedly covers the entirety of NT 23. The question before your lordships, for your kind consideration is, what is the scope of 50? Because 50 also has a reference to law made by Parliament with regard to a subject matter, that is mineral development.
But even your first proposition may be a little overbroad, that a law made by Parliament under entry 54 of List 1 subsumes the entire content of entry 23. That may not be correct. Because then that would be glossing over the words to the extent to which.
Quite right.
To the extent Parliament has covered a field under entry 54, that field is taken out of entry 20.
I agree with your lordship's observation, but only one thing I was wanting to say. No one has suggested to you that something else is left out in the 23 which is not covered. But this is a broad proposition.
Right.
Which is an accepted proposition. If there is some issue, somebody can say, no, there is still some, if it's left in 23, it's all right.
Yeah.
But no one has claimed that they are such a right. And the decisions of this court, starting from Hingiri Rampur till India Cement, all of them say so. That NT 54 really subsumes, covers the entirety of the subject matter of NT 23. There is no caveat on that at all. Now the question is, 50 is a tax entry, no doubt. And that is how, my lord, the arguments were advanced from the survey of the state, that look, you go by what the Supreme Court has said, my lord, since Sundaramaya, that tax entries are independent, ordinance, other entries are general entries. Tax entries are not governed or controlled by, this is true, my lord. That's the arrangement of the, broad arrangement of the Constitution and various items in the seventh schedule to the Constitution. The broad classification. So Sundaramaya was not considering, my lord, are there any exceptions at all? First, they were not considering that. Broadly, you see the tax entries are separate. The general legislative entities are different. They generally they don't overlap. But 50, everyone has accepted, my lord, that 50 is a sui generis provision. It is a tax provision, no doubt, but it allows a law made by Parliament, which is not with reference to a tax entry, to control it by giving laying down limitations. A limitation, my lord, I think is the word of the word is used of wider import. Limitations will not have no limitation. Limitation would mean any kind of limitation. Any kind. How the Parliament would have visualized, my lord, we cannot. From time to time, you can only test the Parliament's power when it has exercised that power of limiting the scope of entry 54. Whenever the matter comes up before a lordship's, my lord, you will test it, whether it is limiting or not limiting. But there cannot be, my lord, a broad theory that limitation means only A, B, C, D and not D, E, F.
Limitation of the type that we look into from 54 itself, that is, has to pertain to regulation and
Of
development.
course, no doubt. Those are the most important words, my lord, qualifying. So those words bring us back to entry 54, because entry 54 is the legislative entry which authorizes the Parliament to make law on that subject. Regulation and development.
To that extent, it is not absolute.
No, it is not. It is not. I'm not saying such a.
No, I mean, we just.
It's a law
Like
made
to
by
understand-
Parliament in
understand what
exercise
you're
of
trying
its
to say.
powers. Under power is of course 246, but it's subject, which is a general subject. Parliament has been given the power to regulate this by limiting the taxing power of the state. That's the significance of this entry, my lord. Now, having said that, my lord, that's the scope. First step in the interpretation of entry 50. The next what my friend Mr. Singh was trying to argue. If you look at the entry, my lord, it is not a tax on minerals. That could have been so. Very simple thing would have been, my lord, Constitution to say taxes on minerals. And then you say what are subject to, etc., etc. But the Constitution makers have not said so. They've chosen a different expression, not minerals. Taxes on mineral rights, obviously, because they were aware that there is a clear distinction between mineral and mineral rights. They're not one and the same. My friend has already given you that exposition. So therefore, while your lordships are interpreting my lord entry 50, kindly bear this in mind. This is my humble request. That the entry would have to be.
I have to ask you.
It's different. Quoted a mineral open. 4H. और एज को थे नहीं, 4H नहीं है.
Anguli, what is the core of your submission?
Core of submission is this, Milord. The scope of entry 54 is not an entry with reference to levy of taxes on minerals.
Entry 54. No, entry 50. That we got. I made a note of that.
It's not an entry for taxing minerals.
But mineral rights, that as you
And
rightly
it is-
said, Dr. Singh,
I has chosen to use a different expression, mineral right. Obviously, Milord, it has some meaning. And I cited some of the literature on the subject, corpus juris,
Fair
etc.
enough.
I will give you a lordship to
Fair
refer.
enough. What is the next point?
Milord, so therefore, this power has to be only with reference to mineral right and nothing else.
Right.
The question is, has Parliament made a law with reference to entry 54 restricting that right, which is authorized, not mineral, but mineral right? Has Parliament enacted a law with reference to development of mines and minerals, restricting or limiting the power of the state to tax mineral rights? So if the first concept of mineral right being only a right to extract mineral and not a right in the minerals themselves, there's a world of difference between the two.
On your fourth point, has Parliament enacted a law limiting the power of the
Limit-
states to tax mineral rights?
Is the question, Milord, then
Your answer is yes.
Yes.
The MMDR Act is that sort of a law.
you're quite right. And to understand that, Milord, what would have to be investigated or looked at is
Yes.
whether the parliamentary law really restricts the right of the state to levy of that kind of tax.
So how do you, what is it, without reading the Act, how according to you do you say that, well, that is a law which restricts a limitation under entry 50?
Now, Milord, if the right is to only the mineral right, if the tax is to the mineral right, then that would only mean that someone who holds the right to extract the mineral, which would be Milord by a grant of a lease or some other authority.
But then are you conceding the fact that there is no limitation imposed by Parliament on the right of the states to tax mineral rights?
No, I'm not, they have that under the entry, yes. But now the next question is, has the parliament put any limitation on that or not?
Right. So
I'm on that.
has Parliament, has one aspect is that you are saying it's not a tax on minerals, but a tax on mineral rights.
Exactly.
But according to you, has Parliament left the area of a taxation of mineral rights open to the
No,
state?
it is not. That's what it's coming to. Therefore, Milord, the law of the parliament would have to be tested from that angle. Has it left open or has it decided?
According to MMDR has not.
Covers that. It covers that field.
Right.
It provides for levy of, Milord, for example, the dead rent. Dead rent is nothing but, Milord, a tax on a right to extract mineral in future time, as and when you think convenient for you. And another important thing you also notice, in the schedule to the act, the dead rent, the measure of dead rent is not per ton, etc., as you find for royalty. Dead rent measure is the extent of land, acreage. That's important. If you Lord should have a look at it. Second schedule. Below, dead rent is provided under section 9A, corresponding schedule
Don't remove mineral.
is below the third schedule. And I would invite your lordship's attention to that schedule because you have not been shown so far. That provision.
For not exercising right in respect of
You
mineral.
have the right, no, you have to retain in the right, not
Nothing to
exercise.
do with mineral, exercise of mineral rights as such. Because you are not utilizing the right conferred on you, and therefore you are.
No, I would put a beseech your lordship, kindly to consider. But what I will say is, you are holding on to the right, therefore you have to pay this tax. Not that you are not exercising. You are exercising the right by holding on to
No,
that
but you
right.
pay
That's all you
either
are.
royalty or dead rent. If you are liable.
If you are working, then of course.
Right, whichever is higher.
That is because that's not a mechanism to get more money. That's a different matter. Because it's an option for a lessee either to work it or hold on to the right. But I'm only on the point kind of similar to Schedule 3. That gives your lordships an idea as to what is there.
Therefore, a lease of mineral bearing land is not like a lease of any land. Suppose the government grants a lease in respect of some land. Government is still, we know that they provide for forfeiture if you have not constructed within a particular period. The idea there is that, well, you have taken a lease for a purpose, you must utilize it for that purpose. Similarly, the same concept in regard to dead rent, that, you are bound to fully exploit the mineral potential of the land which has been leased to you. If you don't,
Then you have to pay this. No, bro, there was a situation which I'll bring to your lordship. That's another point I have to bring. There had been umpteen number of cases, my lord, where, I'm sorry, there are lots of some discussion. My lord is in this third schedule, my lord, it says.
it's on acreage.
Rates of dead rent.
It's on acreage.
It's on acreage. Per hectare per annum. So that is what is not contemplated to be the right of the state to tax under entry 50. But that is now being regulated, or you put it in the language of 54, limitation.
The reason why it is on acreage is because no mineral is extracted.
Exactly.
Therefore, a dead rent. If
But
mineral
it
is
is taxing the right.
extracted, then it is a royalty on the mineral.
Quite right, absolutely right. I bowed down to that observation. But when you are taxing the right to extract, that is the dead rent is in the nature of your right to extract mineral which comes squarely under
That is the
50.
question whether payment of royalty or dead rent, whether it is an exercise of mineral right is the question. Or it is something else.
The exercise of mineral right is holding on to the right. When you exercise that right and you produce pursuant to that right, you are in a different scenario altogether. Because now you have accepted the mineral, they're out.
Fair enough. Now, what is the next point, Mr. Ganguly?
And just to give a lordship an example, because my lord, the Chief Justice was pleased to observe that yes, it is a kind of a deterrent that so that people don't sit on their property and you don't allow the development of the mineral, though Parliament has desired to do so by enacting this law. Similar to what happened was there is a concrete scenario. Large number of private leaseholders had acquired leasehold rights but never used those rights. Large number of areas. So what the Parliament then had to intervene to enact a law called the Toll Bearing Areas Acquisition Act. Acquisition and Development. Though that law would be referable to some other entity under this 3 for acquisition is only there. But this law was enacted for the purpose of giving effect again to the mandate of entry 54 for development and regulation of minerals. And that act was challenged by, actually the suit filed was basically by state of West Bengal in this court. Challenging the parliament's power to enact such a law. So their contention was, these are our property, how can you acquire our property? We are sovereign. So our sovereign rights can be acquired by parliament, that power is not given. The Rothschilds negative that argument and upheld the validity of the act. There is a constitutional judgment. I'll give you also that judgment is here. And then what happened, interestingly, as a result of that act, all rights of the existing leasehold rights, whosoever had added, right to extract minerals, those vested in the center under the act. But that act, Parliament authorized the central government to get the mines work through government companies on such terms, etc., as they choose to. So that act was given effect with that manner, where the government companies came in and given. States will not then question further to the government, to the central government, saying that we don't get any royalty from these because you have acquired our property. And it's a huge loss of revenue. So central government accepted this, and eventually Parliament amended the law in 1971 and made a provision under that act, introduced new provision, section 18A, enabling payment of royalty even in respect of these lands which are vested in the central government. That act I have to place before you, because one place in which I am appearing that directly relates to that case. That act you also will find is that volume 4L. L. 4L, page 2. Volume 4L, page 2 of that volume, you will get that act. I have to place that, I'll come to it immediately.
What is the next point now, Mr.
Yes. The other point which has been already argued, but I owe a duty to the court to explain to your lordships what happened exactly in Keshwaram. How did Keshwaram come to be referred to a bench of 5 judges? That Keshwaram itself extracts. I have to show you that. What is the controversy that the Keshwaram was asked to decide? It was not whether the tax on royalty is a tax on mineral rights or on minerals, and whether royalty is a tax or these are none of these issues were conversed at all there. I'll immediately show you that that judgment. I will show you quite a few paragraphs. So the scope in Keshwaram was completely different. This was not an issue at all. And much less reconsideration of what happened in the Indian cement. But I have to give it to the ingenuity of my friend, Mr. Dwivedi. After the hearing was concluded by the Constitution bench, he came out with his hearing is closed. He came out, stood up to say, there is a point that there is some kind of a typographical error in the judgment. This was attempted to in an earlier case, in the Odisha cement case, but given up. This was raised, so we asked the court, are you going to take up this issue now that the hearing is concluded? So Chief Justice Khare was presiding the bench, said, certainly not. It was a closed chapter. So nobody addressed any argument to that bench at all on this question. Whether there was an issue or not, let's not go into that. This is a factual thing.
Fine, why to go into all that? Actually, we will really go into a unnecessary quagmire, if we start now.
This is an historic fact. Unfortunately, we didn't have the transcript facility in those days.
To come another case then. Whether it was argued, not argued.
Yeah, that's why your lordship find, my lord. Lordship do not find any mention at all in the dissenting judgment of
Kesharam
Justice Sinha.
has just that limited significance because that was one of the reasons why the reference was made to us. Now, once a reference is made to 9.
I'll leave it at that, my lord. I only just pointed out to how it had happened, but that this is important to know, my lord, that in Kesharam, this was not an issue at
If we
all.
were a bench of 7, then certainly whether Kesharam could have done this, whether there was an error in judgment would have arisen. So we would be bound by judgment. We were a bench of 7.
May I just take your lordship then through that Kesharam's decision only?
No, not necessary, Mr. Ganguly. Not necessary.
No, I'm not going to that. I'm only showing you what is the scope there and how it has been dealt with.
That's okay. We'll look at your note. Something on the core now, if there is.
Yeah.
Otherwise, we'll conclude.
Just one
Mr. Ganguly.
paragraph, my lord. Should permit me, volume 5 plus 1.
Not necessary to read Kesharam.
No, I will not. I would not read. I will only give you the lordship the paragraph.
After Mr. Ganguly, Mr. Bagaria will be arguing next. Who?
I think sequence Mr. Bagadia, Kambata, myself and Mr. Gu. Subject to 3 o'clock.
Mr. Bagaria, Mr. Datar, Mr. Kambata, and then?
Is somebody raising both the palms? No, I said, is somebody raising both the palms? Because we found many.
Only one. No, then let me take your lordship to the Cultivating Areas Act directly, because that's an additional point. So may I visit your lordship kindly to see, my lord? Volume 4L.
What do you want to refer to it for, Mr.?
My lord, for the Coal Bearing Areas Act, your lordship have not seen that. And where there is directly an argument that once the mines come out within the purview of that act, the tax under entry 50 in any case not leviable. So I want to show you also that act, how relevant.
But do we have to deal with that? Let a smaller bench deal with these issues, particularly, I think.
What is the effect of the act?
What is the effect of the act? We shouldn't really.
Imposed by the parliament.
No, this is also,
Mr. Dwivedi, I think that's a better course of action, isn't it?
this also, my lord,
Otherwise, we start interpreting individual legislations, then we'll miss some legislation. That's not the scope of this reference.
It's a parliament.
Yeah.
no, we're not questioning the validity.
Broad aspects of the legislations can be kept in view.
Volume बोलना है.
Anything else, Mr. Ganguly? Or we
So
can
if you also just
Bagaria.
permit me to, my lord, this is an act which is important for the reason that it will throw light as to the scope of, my lord, entry 50. That's why I just want to tell you also what it is all about. We are not asking you also to adjudicate on the nitty-gritty of that provision, no. So volume 4L, if you also will kindly permit me. Page 2. If you also will see the objects and reasons at page 2.
Show us the relevant provision, Mr. Ganguly.
The provisions are, first, if you also will kindly permit me to.
4L.
Yeah, let's go to.
4M.
First, see, the preamble. If you also not go to preamble, mirror at page 5. Okay.
You're making, and then we can maybe look at everything again.
Section 4 is the preliminary notification which is issued by the central government once the central government has come to the conclusion that coal is likely to be obtained in an area. So, section 4. Then, my lord, a notification under section 5. It is similar to, my lord, the land acquisition proceeding provisions. Effect of notification, what happens, my lord, all prospective license, mining leases, they all cease to have any effect at all. The whole purpose was to acquire, my lord, the mining rights of those who are holding on to the leases and not operating the mines at all. Then section 6 is a compensation to them, Lord, that's not very relevant. Section 7,
Because, I don't think that's been the scope of the reference. It's not argued this side. If we leave the interpretation of the act, the impact of the act on the, on the appeal or whatever there is before the regular bench. Let's not go into the.
I understand that, Your Lordship, can leave it to the regular bench to go into the question of interpretation if there be any. I was only giving Your Lordship the scheme of it. It's just similar section 10, what happens?
Let's leave it, Mr. Ganguly. I don't think we need to go into the act. Unless there's a formulation which you have and then want to just sort of illustrate that formulation with reference to a particular.
I'm referring to this act for the formulation, Lord, that this is a clearly an example of how you can, the central government can control in exercise of its powers under NT 54 and some other powers. This is also NT 42, or at least 3, because acquisition is specifically dealt with under 43. But 40, the power of acquisition was exercised, my lord, in furtherance of its obligation under NT 54. That's how I was reading to your Lordship, my lord, the preamble. Preamble says, my lord, is that that we have large deposit of minerals, they remain unexploited, they are required for the betterment of the country and in the larger interest of industrial development in the country. Therefore, my lord, they cannot be left to be unworked for all these years. So we should acquire. That was the whole argument. So this is nothing but augmentation of a law and in terms of
anything else, Mr. Ganguly? Anything else? No?
NT 54. But a few portions, my lord, I have to show to your lordship from the India Cement judgment, just 1 or 2 paragraphs, to indicate how, my lord, India Cement dealt with the issue. So if your lordship will kindly permit me, it is volume 1, page, sorry, my lord, it is volume 5H. No, Lord, I told this. Volume 5. My lord, volume 5.
I was just reading it.
Page, my lord, 1151.
Royalties traceable to NT 20.
Yeah.
33 of India.
It's okay, I got it. I have 33
33 also is got.
Page, my lord, 1200. No, first, your lordship will just once again, my lord, see the question that was formulated by the court at page, my lord, 1155, foot of that page. Question involved in the previous special petition and the writ petition is whether levy of cess or royalties within the competence of the state legislature. And they go on to discuss this, my lord. Then Well, at first paragraph 24, at page 1166. There, the lawsuits are discussing the scope of entry 15 of list 2. And then, referring to Anant Mill's case, they also say, all minerals which are under the earth can contain, under certain circumstances, fall under the expression land. But a tax on mineral rights is expressly covered by entry 50 list 2. If it is not under the head taxes under the 49 of list 2, they will render 50 redundant. So that was the argument not with regard to entry 49. Then kindly turn to paragraph 29 at page 1168, where the lordships are now discussing the case on HSI Murthy's case. Murthy's case was the issue whether Murthy has correctly laid down the law or not. And
So only what are you driving at actually?
Paragraph 20.
What are you driving at?
What I'm driving at is, India Cement was directly concerned with the question as to whether royalty is a tax or not. Why?
Yeah.
Because their lordships are considering the validity of the earlier judgment in Murthy's case. Murthy said, a tax on royalty, that's what it says, on royalty is a valid tax. So that was the issue which was before the court. The court was examining whether that is correct law or not. It is in that context, their lordships observe at paragraph 29, page 1168. The passage is quoted from HSI Murthy's case. Last 4 lines of the passage. After having said, that says is valid on royalty, the lordship says, our attention was not invited to the provision of any law created by Parliament. In the context of section 78 and 79 of the scheme of those provisions, it is clear that the land says in the truth a tax on land under entry 49 of the state list. This is what Murthy had held. Now they are considering correctness of that properly. Next paragraph, paragraph 30. It seems therefore.
33 could be what you are driving at, I think. 33, para 33.
Yes.
I think that is where.
I was going to 33, but I want to show you first also this, that the lordships found that section 9 is the provision under the MFDA Act, which covers that. That is stated in paragraph 30. And what the lordships have said is, last sentence, on that is tax on royalty is not a tax on mineral right. It would therefore be in any event outside the company's state legislation. So they made again a distinction between mineral tax on minerals and mineral rights. And in 32 first, and 33. 32 first, it is contained by Mr. Krishnamurthy that the state has a right to tax minerals, which is completely different from what is the scope of entry 50. Now, that is being dealt with. Paragraph 33. In any way, royalty is directly relatable only to minerals extracted and on the principle that the general provision is excluded, while the special one, royalty would be relatable to entries 23 and 50 of list 2 and not under entry 49 of list 2. While the fee is covered by the central power under entry 23 or entry 52, the impugn legislation cannot be upheld. And then paragraph 34. Having said this, they clearly said that royalty is a tax, and the cess on royalty is beyond the permissible limits of the power of the state. Then the lordships go on to discuss paragraph 34. See the beginning. In the aforesaid view of the matter, we are of the opinion that the royalty is a tax and as such cess on royalty, being a tax on royalty is beyond the competence of the state legislature because section 9 of the Central Act covers the field and the state legislature is denuded of its competence under ND 23 of this 2. Then the last sentence in any event, we are of the opinion that the cess on royalty cannot be sustained under ND 49. That's another argument. And then the royalty on a mineral right is not a tax on land, but on payment of the user of land. Now, this is being picked up, this last sentence, to suggest that India Cement did not have the occasion to decide whether royalty is a tax or not. That, with great respect, that is the genesis of, Kesharam's beginning. That's how the Kesharam begins, that say, to distinguish this judgment, of 7 judges. And that's how the Russians have found some possible error, etc., etc. Whatever is that. That part I don't want to go over it. But this is because of incorrect reading, of this paragraph 34, which flows from what has been held in the earlier 2 paragraphs. And it is very clear from the earlier 2 paragraphs that cess on royalty is a tax. Royalty is a tax and cess on royalty, therefore, is forbidden. Very clearly says so. And there's also a reference to a judgment by Justice V.S. Verma, then he was then there, as his lordship then was acting Chief Justice. He has also held that the development says under Section 9 of the Madhya Pradesh Act is ultra virus. But they also did not go further into it because the appeal was pending before this honorable court.
Repeatedly, royalty.
But I was referring to that coal bearing areas act for the limited purpose, that how does that act also reflect on the interpretation that you're also going to place on entry 50 is this. That's a law which has acquired all the rights of the existing leaseholders. And then the government, in furtherance of its objective under entry 54, for further development of mineral development, has compulsorily directed that those lands would have to be developed for the purpose of mineral development. And that's how they appointed the government company. That act now provides by an amendment to Section 18A without payment of royalty. So these government companies are paying royalty to the state because of that new introduction under Section 18A is from 17, from 1971. At the same time, now there is a further demand under the Odisha Act from the same companies by saying you now have to pay a cess, which is not calculated again at the rate of royalty.
Okay, thank you, Mr. Ganguly. We'll, now, after lunch, Mr. Bagaria, we'll hear you after lunch. For 15 minutes, we'll give Mr. Bagaria and then Mr. Dada.
May I address after Mr. Bagaria?
We are going to conclude all arguments on this side at sharp 3 o'clock. One second. All of you sit down together. Whoever, 1 second. We are not going to do this. We are not going to haggle duration time between counsel. That's for you all. Between all of you, you decide you've got 1 hour. Who will take what? If one person takes the entire hour, I'm sorry, we'll have to conclude at 3 o'clock. So we leave it entirely to your good allocation on who will allocate, how you'll allocate time the last 1 hour before you conclude.
I'll take 5 minutes because my case is completely different.
My English seems to be improperly understood. You may take 5 minutes, you may take 50 minutes, you may take 59 points, 59 minutes, 59 seconds. But that eats into somebody else's time.
Just 5 minutes.
All of you.
Your Lordship will
Why don't you understand what I'm trying to say?
Yes, my Lord.
Why don't you understand what I'm trying to say? At 20 counsel, if you take 5 minutes for all of them, it goes to 100 minutes. So between all of you, at lunch as you leave the court, please ration out the time inter se. We are giving now 1 hour. We have made it, yesterday we said till 2 o'clock. We have extended it by 1 o'clock, by 1 more hour. 3 o'clock, Mr. Dwivedi will start arguing. Between all of you, decide how you will divide that 1 hour between ourselves. We have no difficulty. We'll hear everybody within that 1 hour.
May I just say then that will your lordship segregate that Mahanadi coalfields and refer it to a regular bench? Will your lordship segregate Mahanadi coalfields?
What's segregated is done tomorrow.
That segregation we'll do tomorrow.
Respondent number 87, because
We
that's
can't do it like
covered by the
this. We
central
can't do it like this. You know, there'll be a mess if you start
Very
just
well.
throwing things like that.
Very well.
What is
We are looking at this.
My lords, on-
sequentially. Tomorrow, all of you give us that these are the matters which have to be detailed. That's why we said that.
Will do, right.
My lords, on behalf of the NTPC, we'll go by what the learned solicitor has said, my lords.
All right, Mr. Bagaria, then after that followed by Mr. Khambata.
Yes, my lord,
Yes,
I'm-
yes.
And, yes, yes, Mr. Bagaria, Mr. Datar, Mr. Khambata.
Lord Smith put Kambata, he's got some difficulty after.
All right.
Let Kambata go first, I'll follow him.
All right, so Mr. Bagaria, Mr. Khambata, and then Mr. Datar.
And
Yes.
will not be allowed.
All within 1 hour.
5 minutes.
We'll try, we'll do it. If your lordship says so, we
You
have.
may be entirely right, but just appeal to the seniors who are preceding you, that's all. So sorry, I'm responsible for the delay. I had a meeting which spilled over, that's all.
Well, we have divided that 60 minutes between ourselves.
It is coming to 62 minutes. Juniors want one
All
more.
right. So, Mr. Bagaria, how much of the allocated time do you get?
20 minutes. Ma'am.
20, all right. Let's get started.
I'll try to finish up with that.
Thank you.
Well, I'm appearing in two of these matters. Civil Appeal 1883 of 2006. That is our Steel Authority of India. And a brief synopsis is filed, that is at page 43 of volume 2A. Lordship need not open it, I will not go into that. Civil Appeal 1883 of 2006. And the second one is Civil Appeal 6135 of 2013. That is in the case of Birla Cement Works.
What is the submission, Mr. Bagaria?
Alright.
What is your submission?
Alright, this first submission, I'll straight away come to entry 50.
Sorry?
I'll straight away come to entry 50.
Right.
Because much has revolved around entry 50. I did not read that, your lordships have gone that a number of times. It is into three parts, or if I may say, three attributes. Taxes on mineral rights. That's the first attribute. Subject to any limitations imposed by the parliament. That is, my lord, the second attribute. Third attribute is by law relating to mineral development. Now, each of these three attributes are very, very carefully worded and very carefully put into the entry. Now, what is the uniqueness of this entry? It much has been submitted. I adopt all the submissions of the learned solicitor and earlier counsels meant. If I may summarize, in all the taxing entries in list 1 and list 2, this is the only entry providing for subject to limitations, subject to any limitations by parliament. So that sort of restricted coverage is not in any other entry. Kindly mark the expression subject to any limitations. So, my lord, the entry itself is not unrestricted. The entry itself is giving the field, as your lordship said, well, these are the entries for the legislative fields. The field relating to taxes on mineral rights. That field is allocated to the state legislatures. But that allocation itself is conditioned, restricted, and subject to. But that conditioning can only be by a law, imposed by law, made by the parliament. And that law must relate to mineral development. Parliament may make any sort of law. It may make hundreds of laws. But no, for imposing the restrictions under the entry, it must necessarily be a law relating to mineral development. Well, these are the three attributes, very carefully chosen words. Any limitations imposed by parliament, by law relating to mineral development. Now, if you look into the lists, the only entry providing for a law made by the parliament relating to mineral development is 54. Because law made by the parliament is only in list 1. Leaving aside list 3 for the time being. And in list 1, 54 is the only entry. Kindly also mark at this stage one important fact. I checked up all the three lists. This expression mineral development that appears only in the three entries today, what is being considered by my lords. 23 of second list, 50 of second list, 54 of first list. All the three lists, they use the expression mineral development. This expression is not appearing in any other list. So what is the significance? Immediate question your lordship raised, my lord, earlier also. All right. If that be so, how do you denude the state legislature of the power to levy taxes on mineral rights? My utmost respectful submission is that denudation automatically comes in by reason of the entry's own limitations and restrictions. That is a constitutional limitation inbuilt in the entry.
Comes in?
By reason of the entry itself. How that comes in? The moment there is a law made by the parliament under 54 by 1, 54 list 1, and that touches on the mineral development, then to that extent, the denudation occurs. And the entry's power gets eclipsed to that extent. Immediate next question would be, all right, what is that law?
And what is that extent?
Yes.
What is that extent?
Absolutely. But my lord, the Honorable Chief Justice on that day was putting the question, by whom, how, and what? By whom the parliament, the entry itself is. How? The entry says by law relating to mineral development. And what? For that we need to go to MMDR. Now, my lord, MMDR was placed before my lords in extenso by the learned solicitor. I won't take your lordships into all the sections again. Only I may give a reference to some of the sections. Your lordship may make a note of that. What MMDR does, every possible conceivable concept relating to mines and mineral development gets occupied. And gets occupied along with the financial obligations, along with the finances, along with the limitations. And if that be so, if that is the correct reading of MMDR, what necessarily follows, subject to any limitations imposed by Parliament, that comes in. So that limitation on the state's powers.
But assuming that the MMDR occupies every possible field of mines and mineral development, does that impose a limitation on the taxation of mineral rights? That's the question you have to answer.
Does that impose a limitation on the taxing power?
Right.
Taxing power. That is the question.
Right.
That is the question.
Which are those provisions? Just tell us.
No, not the provision. I'll tell you, lordships. What MMDR does, your lordships have seen the preamble and other things.
Right.
Statement of objects, etc., etc. There are 2 or 3 very important features of the MMDR.
Yes.
All possible conceivable rights, reconnaissance, mining, and other connected obligations and rights, they're all taken care of in MMDR. Connected to that, as an intrinsic measure to the development and regulation, MMDR provides for various financial obligations which are in the nature of imposts. I will not use the expression tax for the time being. but they're imposed. Whatever meaning we may give to imposed, that is defined in 366, let us confine to that meaning. So different types of financial obligations are being created by MMDR. Not only created, my lord, along with the limitations inbuilt into each one of them. So the moment that limitation on the financial obligations gets created by MMDR specifically, then those limitations cannot be breached. Then that is what is the occupying of the entire field. That entire field is getting occupied by reason of making the provisions for mines and minerals in all their aspects. Along with what are the financial outgoes which are.
But there's a fallacy. The field of taxes on mineral development, that cannot be occupied because it's a field exclusively assigned to the state.
That is why
Occupied field can arise where an entry in the state list is subject to an entry in the union list. Union occupies the entire situation. Alternately, it can occur within the concurrent list. Now, in this case, the entire field of taxation of mineral rights is assigned to the states. Therefore, it can be only by virtue of a limitation under the Central Act that the states are precluded from exercising the right to tax the mineral development. Now, where is that limitation?
that is what I was coming to, madam.
How do you trace it? Occupied field will not help you.
Madam, that is what I was coming to.
Because the field is exclusively assigned to the state subject to limitations.
So madam, that subject to, we cannot bifurcate.
Right.
That subject to is a part of the entry. That subject to is inbuilt as a limitation.
You show us which are those limitations which have been imposed under the MMDR Act, which affects the taxing power of the state.
Kindly allow me to place only the relevant sections.
Just tell us, you can enumerate and tell us what those sections are.
I'll enumerate in this way. Let us start with royalty. Going to other sections also, I'll just give the section numbers.
Yeah.
Well, royalty, the rates are fixed. They are on all India basis to maintain the uniformity by reason of the national importance of minerals. Not only the fixation of the rates, they are coupled with the right given to the parliament under subsection 3 of 9 to amend or enhance once in 3 years. So even if the parliament itself desires, that revisional process or exercise cannot be done in violation of subsection 3.
Right.
So the totality of the rights, totality of the outgoes, totality of the imposts that can be levied in respect of that particular exercise, that is inbuilt in the section. Now, if on that, what is royalty? My lords have been discussing it for last few weeks. One thing cannot be denied, whether we call it a tax, whether ultimately what your lordships holds. Definitely, the right in that mineral, which is taken away after extraction, that is parted with. That mineral is gone. And that is why it is on per metric ton basis or ad valorem basis, depending upon how much do you take and extract and dispatch or you consume. Now, kindly note one important aspect. In any of the 3 lists, well, the state has not been given or let us say there is no entry providing for taxes on minerals. List 1, list 2, list 3. There is no entry called taxes on minerals. That has been gone into in India Cement also. It has been specifically noted. So the only entry on which state can fall is 50, taxes on mineral rights. Now, if that right gets eclipsed by reason of the limitations imposed by Parliament by a law relating to mineral development, and that is MMDR, then so long as that limitation continues, that eclipse continues.
Which are those restrictions?
Bagaria, you have 5 minutes to go for your 20 minutes to end. Please tell us which are those restrictions?
Very good.
Which are those
Very
limitations
good.
under the MMDR?
Kindly just make a note of the sections.
Is it a tax on minerals? Under the MMDR Act?
Royalty is a tax or not a tax. That is a separate issue. Now, royalty is definitely calculated if your lordship sees the sections.
What is your submission on royalty?
But if your lordship sees section 9, on what basis it is being payable? Just allow me to place section 9 only.
Just formulate it. We have seen it now many times. Just formulate it.
The holder of a mining lease.
No, what is your submission? Don't read it. Just formulate it.
These 2 lines reading is important. I will not read anything further. The holder of a mining lease granted before the commencement of this act shall, notwithstanding anything contained in the instrument of lease or any law in force at the commencement, etc., pay royalty in respect of any mineral removed or consumed by him. So the conditions precedent are, he must be a holder of the lease. Now, by reason of holding of the lease, we acquired the mining right or the mineral right. And then the calculation that is getting quantified based on how much is extracted and dispatched. So whatever way ultimately your lordships may decide, whether it is a tax on mineral right or a tax on mineral, state cannot get the jurisdiction.
But is it a tax at all?
Doesn't matter. Let us call it impost. Let us call it a levy. That field by reason of this levy, that is getting occupied. Irrespective of it's being called a tax on mineral or not. Because even if it is a tax on mineral.
Field of royalty is occupied. You're right.
Well, a tax field of that financial imposition, that financial impost on exercise of that right, that is getting occupied. And well, if you see the entirety of the act, as the learned solicitor was pleased to place before my lords, every aspect, prospecting, reconnaissance, mining.
All right, anything else, Mr. Bagaria?
Just within 5 minutes, I'll complete.
3 minutes left. We'll be holding. You will down to the finish now.
Kindly take the sections. Sections are, my lord, 8, 8A.
Section 8.
8, then 8A.
Yes.
9.
Yes.
9A. 9B. 9C. 11D. 13. 18. 25. These all relate to different types of financial obligations and financial matters, financial outgoes.
So according to the field of royalty is occupied, including all financial imposts on the exercise of these rights.
My lord, not only royalty.
That's why I said including.
Everything connected to mines and mineral obligations. I mean,
all financial imposts.
All financial obligations.
All right,
and
thank you,
they are
Mr.
getting occupied as an intrinsic part of development and regulation.
Thank you. Thank you.
Only one section, we have got a note, section 28.
Yes.
Even the notification by which the rates are changed that 3 yearly, that is required to be placed before the parliament with approval depending upon.
Thank
etc.,
you.
etc.
Yes, Mr. Datta, thank you.
My lord, can we make a note of, the other day Lordship asked, how can a form, that is form K, in which the lease deed is given, that have any bearing? My lord, this form K is a statutory form under the section. Kindly only make a note of those sections.
That's okay. It was statutory form. No
See,
difference.
statutory forms.
Absolutely.
So there is a
Okay, we got the point.
judgments.
Yes, Mr. Datta. Thank you, Mr. Bagaja. Yes,
Kambata
Mr.
will
Datta.
take 10 minutes. You wanted to finish first.
Who?
Mr. Kambata.
Mr. Kambata.
May I be,
Would you Lordship give me 1 more minute only?
No, Mr. Datta. Thank you.
My lord, 1 more minute only for mentioning the name of an act. Only for mentioning the name of the act.
What is the
The
act?
other day, Lordship asked the question, is there any other law under 54 relating to mineral development? There are 2 other laws relating to coal. One is Coal Mines Conservation and Development Act 1974. That is at page 1873 of volume 4.
We'll look at it. Yes, Mr. Kambata.
no, I'm grateful to your lordship for giving me this opportunity of addressing virtually. I'm sorry, my lord, for personal reasons, I couldn't be here physically before your lordship. So, my lord, I'll restrict myself. I have 10 minutes and I've heard the argument, my lord. I know what apprehensions are troubling my lords, and I seek to address those. Lord, I want to make 5 points on entry 50. As we have seen, entry 50 permits the states to tax mineral rights, but it is subject to any limitations imposed by Parliament by law. The first submission, therefore, is that the states do not have exclusive competence to tax even mineral rights. I'm not getting into the issue of whether mineral rights is narrower than minerals, but that has been dealt with. But whatever the subject matter is, the states do not have exclusive competence. It's always subject to Parliament. I say this because if my lords see my written submissions in volume 2G, pages 2 to 17, I have extracted a portion from the case in H.S. Dillon, which enunciated the test thus. It said any tax, any matter, including tax, which has not been allotted exclusively to the state legislatures, will fall into the province of Parliament. Because as we know, Parliament has the residuary power to tax under Article 248(2) and read with entry 97. So unless it is allotted exclusively to the state, it would always fall within Parliament's power. That's point number 1. My submission is...
Mr. Kambata.
Yes, madam.
Allotted exclusively to the state legislatures is not inconsistent with limitations on the exercise of the power.
That is right. That is right. I accept that. I accept that. I accept that.
Therefore, the field is not given to Parliament. The field is exclusively assigned to the states, but it is limited by a law which is passed by Parliament in the interests of mineral development.
Lordship, please. Maybe take that, Lord, as the... I accept that, Lord. I'm not saying that Parliament can step in without imposing those limitations by a law relating to mineral development. The second point, therefore, is linked exactly to that. That law pertaining to mineral development is empowered by entry 54. And as the paragraph in synthetics and chemicals that Dr. Singhvi referred to, paragraph 40, I won't read it again. It says entry 50 is the one exception to the rule that a power to tax cannot come from a general entry. It says the power can come from entry 54. That's what 7 judges of your lordships held in synthetics and chemicals. More importantly, and I rely on Sirvai, a passage from Sirvai as well as in Hindstone of your lordships, the judgment, the power to regulate will include the power to prohibit absolutely. And if my lords would kindly see my written submissions for one moment, at page 7 of those, para 18, I've set out the passage from Sirvai, which might be of some assistance. Page 7 of the written submissions, para 18.
Just 1 second.
It's volume 2G. Oh, 2G, volume 2G, page 2, it starts, and at page 7. My lords have that.
May I just read that? A tax on mineral rights is made expressly subject to any limitation by Parliament by law relating to mineral development. Consequently, Parliament would have the power to regulate or prohibit the levy of a tax on mineral rights if such levy obstructed or hampered mineral development. And even generally, as I said in the judgment of Hinstone, 1981 to SCC 205, your lordships have taken the view power to regulate includes power to prohibit. Now, if the limitation imposed in entry 50 prohibits, then as felt from the Honorable Chief Justice this morning, there would be a vacuum because then nobody would be able to tax mineral rights, which can never be because the residuary power to tax is always with Parliament. And therefore, if the limitation effectively prohibits, then in my respectful submission, Parliament would have competence not only under entry 54, but also read with its residuary powers under 97 and 248. And the third point is, of course, the very language of entry 50 by law relating to mineral development imports the fact that in this law, limitations at least can be put on the taxing power. Therefore, they can be related to the field of taxation. Your lordships have held in state of Karnataka and Meghalaya also that the word subject to take the entry completely out of the scope of powers of the states. The word subject to an entry 50. I'll show that later if I have the time. The fourth point, and this is, I think, my main point, and others have made it, but I just want to substantiate it, Milord. Entry 54 envisaged a complete code on the law relating to mines and mineral developments. And this would include taxation because of the language we find in entry 50. We've seen the sections, they've been shown to my lords by the learned solicitor. They are extensive, they purport to cover the full range of matters as was held in Tulloch's case at para 12 and 14. But specifically, there is a section 25, which we saw this morning, which permits the government to recover any areas of rent, royalty, tax, fee, or otherwise. Expressly uses the word tax, which means the scheme and scope of the act is expressly, it covers tax as well and a recovery of tax. And Dr. Singhvi has already pointed out why royalty is a statutory impost. Dead rent under 9A would be clearly a tax. And even 9B and C are cesses computed on the basis of royalty, which are in the nature of taxation or impost. Now, the legal consequence of a complete code, as your lordships are familiar with, I have set out at paras 30 to 35 of my note. My lords would kindly quickly go to page 11. Your lordship's judgment in the arbitration and stamp pack matter. I've set out the passage at page 11, relying on the genesis of an idea from Justice Tulsapurkar sitting in the Bombay High Court, that if an act is intended to be an exhaustive or complete code, it impliedly excludes all other laws. So a complete code on mines and minerals which includes the power of taxation, will exclude the state's power. And I've set out a passage from Sirvai. If my lord will just see that at page 11, para 31 of my note, he actually refers to what the consequence of the MMDR Act is was entry 50. He says, and I quote in para 31, in the first of these cases, relying on a judgment of the Mysore Act, it was also held that the state legislatures lost their power to legislate under entry 50 list 2 and the provisions of the Central Act of 1957, and particularly section 25 of that act supported this conclusion. That's the fourth point. The fifth point is that under our constitutional scheme, limitations include implied limitations. They are not limited to express limitations. And if my lords would just kindly see para 11 of my note, page 5, I have extracted some portions from Kesavananda, which explain that everything is not said expressly in our constitution. Limitations can be implied and must be implied. And they can be implied either by necessity or from the scheme of the constitution. If my lord would just see para 11, page 5. Just the first two extracts, I'll just read. From Justice Sikri's judgment to para 210, I come to the same conclusion by another line of reasoning. In a written constitution, it is rarely that everything is said expressly. Powers and limitations are implied from necessity or the scheme of the constitution. And the next two extracts also speak of if you imply that, then it acts as a corresponding limitation on the states, the power of the states or provincial legislatures. So for the very structure and construct of entry 50 read with 54 shows that the intention was to place this entire scheme, including taxation, because one can't delink taxation from mineral development. If a state heavily taxes mineral rights, it might thwart or retard mineral development in that state. The whole idea was to unify it. Now I have 3 points on unification. The first is, and I've said this out, since my time is limited, I want to just point out at page 13 of my submissions, I've referred to the 1948 MMDR Act. Because there was an act before this one in 1948, which expressly contemplated taxation. And one must remember this was made by the Dominion legislature, which was effectively the same as the Constituent Assembly at that stage in 1948. So they expressly permitted taxation as part of the MMDR Act 1940. That's point number one. Point number two is let's go back to the Government of India Act, because now may I request my lords to see para 44 of my note, because for convenience I've set out the respective entries. This is very illuminating. The entries are almost identical. And if my lords see para 44, page 14, entry 36 is the equivalent of entry 54, entry 23 is 23, and 44 is the current entry 50. Now, there are debates of the House of Commons. I agree that they're not authorities to be cited, but it's illuminating to see those debates. And if my lords would just see, I've extracted them for convenience in the annexure to my submissions at page 18. I would have shown them at length, but there's no time. So volume 4, they are contained in volume 4M from pages 54 to 58. And the anxiety of members there was to put to the then Solicitor General in England that should not there be a complete code and should not all powers, including power to tax mineral rights, be vested in the federal legislature? And on provisions near identical to ours,
But you had mentioned the 1948 Act.
yes, madam.
And you said that the expression taxation was specifically used therein.
Yes, madam.
Now, we haven't gone so much into detail, but you see, in the 1957 Act,
Yes, madam.
the taxation thing has come only in the recovery section. What is the difficulty for the 1957 Act to also specifically say taxation? And that would make our task a little simpler, instead of
I understand.
say that royalty is an exaction and go back to the definition of taxation.
Even in the 1948
answered
Act,
in the 57 Act.
Correct.
Although you may be right there that, the Union government has the power to exclusively sort of pass laws on the subject, but has it denuded to the extent of taking away the right of the state to also impose taxation on under entry?
my lord is right, my lord. We are before your lordships because there's not such an express reference. But reading the scheme of the Act, for example, in the 1948, the reference is in the rule-making power. The power to make rules for levy and collection of royalties, fees, or taxes. I've said that out in my para 41. All this is internal evidence to show that the range of the act intended and did cover taxation as well, in whatever name called. Because if you pluck out taxation and give it to different states, there will be a regime which will be inconsistent all over the country. That was not the parliamentary intent. And that the debates which I've set out in Annexure A, I've extracted some of the questions and
Mr. Kambata will have a look at it. Thank you. Thank you, Mr. Kambata.
I leave that thought with your lordships that the whole intent will be subverted if implied limitations are not read into the power under entry 50. That's the crux of it.
Thank you. Yes, Mr. Datta.
Maybe, Lord, I made a PowerPoint presentation, but before Mr. Harish Kambata concluded, there is a very important passage in the Joint Committee in 1933-34, which prepared the Government of India Act. And I'll just flag that the original entry 23 of List 2, said that tax on mineral rights, they were no subject to limitation. And there was a general power given to the federal government. A member of the committee called Lord Percy, he flags the issue and says, if you give complete general power to the federal government and unlimited taxing power to the provinces, then the very regulatory power of the federal government will be in jeopardy. That is why then they put subject to mineral rights. I'll give that passage from Lord Percy, and the Solicitor General agrees. Yes, this is a very valid point, because unlimited taxing power can completely jeopardize the regulatory power of the federal government. Now, my Lord, I'll come to my submission straight away. My Lord, first of all, the taxing powers of the state, there are normal allocation of taxing powers. There are 12 taxing powers given to the union, entry 82 to 96, 92B, and 16 subject matters given to the state government. That is 46 to 62. It's now one less because entry tax is gone, octroi is gone.
And to the union, which was what?
Union 12 subject matters, and to the state 16, now 50.
82
to 92B.
Yes.
And for the state governments, entry 46 to 62. Of course, now 55 is deleted after GST. But out of these 15 taxing powers,
54 is deleted.
Sorry, Murad.
54 is deleted.
55 is deleted.
55.
Entry tax.
Oh, 55. Yes, 55.
Because now it's one nation, one tax, so there's no
Right.
check post and all that. Now, Murad, out of these entries in the state list, 3 entries use the word subject to. Entry 54, the power to levy sales tax, is subject to 92A of list 1. Murad, I'll give a complete note, Murad, to save time. Entry 54 is subject to entry 92 of list 1, interstate sales. Entry 50 is subject to a law made by Parliament. And entry 57, motor vehicles, is subject to principles in entry 55 of list 3. So 3 taxing entries are subject to something. Now, the word subject to has been subject to a lot of interpretation, and a recent judgment by my Lord Justice Gawai and Justice Nagaratna in the case of Baharul Islam, Lordship will just make a note, 2023 SCC online. Page 79, 2023 SCC online, page 79. Para numbers 85 is the most important. Subject to means yields to. So a taxing power which uses the word subject to X must yield to X. Now take 50 minutes. I'll not get into entry 54. If I have time, I'll mention that. So 50 says subject to a law made by Parliament. So my submission is this taxing power is still a state power. There's no question about it. Because all the money goes to the state. All the money goes to the state. But it is subject to a law made by Parliament, meaning the taxing power of the state must yield to parliamentary legislation. And what has parliamentary legislation done, Lord? Lord, I am taking the plea in my slide number 2. Lord, I took the liberty of making a PowerPoint so it will save time. Lordship just sees slide number 2. I'm just going to refer to slide 2 and 4.
Page number?
Slide number 2, my Lord.
Where do we get that?
I made a PowerPoint presentation. I got hard copies if your Lordship wants to save time. Lordship may just take the hard copy. I just got 10 minutes.
No, just one second. But written submissions volume?
No, I gave, Lord, what happened? I gave a written submissions earlier.
PowerPoint. In written
Volume 2 is there.
Come to what page?
For PowerPoint is there?
Folder volume. There's a separate file.
Well, can you just take a hard copy, my lord? I've got 10 minutes.
Quality presentation is there.
Yes.
Very much.
What page number, my lord? Your lordship has got slide 2, my lord. I'll just give a hard copy in case your lordships are finding it. Yes. Now please come to slide 2. Now I'm submitting what Parliament has done. Slide 2, your lordship comes to limitations on taxing power. My lord. My lord, my submission is, all your lordships have got it, my lord? All my lords have got it. List. Yeah. My lord, can I pass on a hard copy in case it's
there in this.
Yes. Now, my lord, I am submitting that when you say taxes on mineral rights, when a legislature has the competence to make a law relating to tax, it basically can decide on 3 components: the levy of tax, the assessment of tax, and the collection of tax. My humble submission is, what Parliament has done is, it has divided minerals into 2 parts: major minerals and minor minerals. On minor minerals, under 15, state can levy tax. In Tamil Nadu, they call royalty on major minerals. They call it seigniorage on minor minerals. But both are basically taxes or imposts. Now my submission is, why did Parliament do this? Parliament did it, in my humble submission, to impose financial guardrails or financial limitations in national interest. And I'll draw a parallel to sales tax. So the first submission is, Parliament has imposed limitations on major minerals. They have set out in second schedule what are the major minerals. They have specified how much you can tax, either so many rupees per ton or 5% ad valorem, 20% ad valorem. And then, my lord, allocation of taxing power, taxing revenues. Insofar as 9 is concerned, Parliament says entire thing goes to Consolidated Fund of State. Come to 9B. 9B, District Mineral Board, it says it will go to the district. It doesn't go to the state. It goes to a trust to be used for the purpose of the district. So what Parliament has done is, this is how the taxing powers has been regulated by Parliament. So they make a law which imposes the levy, but the entire funds go to the state. And this is what I've said. Now, my lord, kindly come to slide 4. Please come to slide 4. I have drawn a map of Tamil Nadu. Lordship has got the map of Tamil Nadu.
Yes.
My lord, what I've done is, Lordship kept asking the question, what is the interplay of 49(2) with entry 52? Now, I'm just making a suggestion for Lordship's kind consideration. Now, tax on land and buildings, land will be a genus and mineral lands will be a species, because not the entire state may not be a mineral. So what I'm submitting is, under the Mining Mineral Development Regulation Act, you have reconnaissance permit, you have this permit, and ultimately a mining lease is given for a period area not exceeding 10 square kilometers. It can be extended depending. So some mines can be 30 kilometers, 40 kilometers, etc. Now, I'm just suggesting to your lordship that whatever is the black dot represents the area for which a mining lease has been allotted. And who gives the mining lease? The state government with the approval of central government. You make an application to the state. And so my humble submission for lordship's consideration is, the black dot area is the entry 50 tax. Rest of the state is the 49 tax. And on the black dot area, they cannot be both a 49 tax and a 50 tax. That's the submission. Now, my lord, third point on why royalties are tax. My lord, I'm very clear, royalties are tax. You can call it impost. That's not quibble on words. It is a tax, it's an impost. And why do I say it's a tax? On India Cements, where lordship sees, the opening page of India Cements is page 1155. And at 1156, my lord, Justice Nagaratna asked the question, what is this royalty? The opening paragraph of Justice Mukherjee's judgment says, India Cements is paying royalty at page 1156 under the Mineral Concession Rules 1960, which is under the 57 Act. And please see, what do they say? Royalty, limestone, government land, 75 per ton, subject to rebate. The schedule. Now, my submission is, what are the indicia for a tax? Typically speaking, because if you apply the Bambach test, royalty is not a tax. Then what is it? Is it consideration? Is it rent? It fails because the indicia for a tax is, it is normally given at a particular rate. The word rebate, ad valorem, schedule, alteration, all these are factors which are very, very unique to a tax. Consideration under 2D contract is nomen juris. It relates to a contractual relationship. In DK Trivedi, Justice Madan said a mining lease is not an ordinary contract. So my humble submission is royalty is a tax. That's the first submission. Secondly, the district mineral board is a percentage of the royalty. That is also a tax. And finally, my lord, I'll say why India Cements was wrong. Oh, sorry, why Kesaram was wrong. India Cements, what happened was the royalty was under these mineral concession rules, parliamentary levy, parliamentary rules. The Tamil Nadu government under section 115 and 116 of the Panchayats Act said the cess will be at 45% of the royalty. They said 45% of public revenue, and then they amended the explanation and said land revenue in public revenue includes royalty. Now, Kesaram says cess on royalty is a tax, but royalty is not a tax. In my humble submission, it's a logical fallacy because 99.99% of the cases in tax law, everybody who practices tax knows, cesses and surcharges are piggyback levies. They're always related to a mother levy. Education says 12.32% of the service tax. Higher education says 0.6% of income tax. So if the cess on service tax is a tax, then it's paradoxical to say that the mother levy is not a tax. And that's exactly what Kesaram does. They say, no, royalty is a tax is a typo, but cess on royalty is a tax. Now, if cess on royalty is a tax, by logic, my lord, the royalty has to be a tax. I'm putting the inverted paradox. And finally, my submission is royalty is also tax because it satisfies all the four tests of Govindaram Gangasaran. Your lordship sees, I've given in the last slide. What are the four attributes of tax? I've given in slide number 8. Taxable event, person liable, rate of tax, value or measure. All these things are satisfied. And finally, not just 1 minute to say how Parliament subjects it to levy. Take sales tax, not just one, I'll conclude. Entry 54, till this Bengal immunity, lordship, there was a full confusion in Bengal immunity, which state can levy tax, United Motors and Bengal immunity. Ultimately, the validation was upheld in MPU Sundaramaiah. After the 6th Amendment, they introduced 92A and said, what was an absolute power of the state was taken away and made subject to 92A. So what happens in 92A? Central sales tax. Central sales tax puts two limitations. It under section 14 makes declared goods, which include many of the minerals also. Otherwise, each state can levy whatever it wants.
Thank you, Mr. Datta.
I think I'm less than 10 minutes. But any yes.
See, not only you, others have also argued this. Money going back or the entire money is usurped by the state. Should that be the logic for?
Yes, I'm very grateful. But I'm just, my Lord Chief Justice also raised the point. You keep saying it's a tax on, it's a state tax. Just think for a moment. Just suppose Parliament tomorrow says, I will make the law and I will keep the entire money with me. That could be a serious challenge because you can't make it a state levy and the entire funds goes to the consolidated fund of India. Because the point is, why I'm saying
that
it's
is simple enough. But if we understand that state has a power to tax.
Yes.
And if center says that, no, I will impose the tax.
For major minerals.
But I'm giving you, one mineral
For major
tax.
minerals. Yes,
right.
yes.
But I'm giving you the entire, let us say entire.
Yes.
Does that satisfy what is given to the state under list 2?
Lordship may not just take giving.
Despite the
Yes. Lordship may not just take giving. Entire assessment is by the state. collection is by the state, special courts are set up by the states. All the parliament is doing is, don't go haywire in your levy. Suppose they levy to the state government. Then any state government can levy any tax. So what I'm submitting is, the very fact that the entire money goes to the state itself shows that the state is not denuded of their taxing rights, taxing money. All happens, the ceiling limit is imposed. Like in sales tax, once you're a declared goods, you can't put more than 5%. Sorry.
56 interstate trade is
Exactly.
by the central government.
Pardon me?
It's only by the parliament.
Yes. Again, what happens is
The power under Article 286
yes,
with regard to
interstate sales.
only the parliament.
Only when parliament can levy.
Only the machinery is by the state.
Yes. Why I gave the analogy?
From the power to impose a tax.
No, why I gave the analogy is, after 6 years of independence, the state's absolute power became subject to limitations. Now, limitations can be in any way parliament wants. In sales tax, what did? They said not more than 5%, only single point levy. For minerals, they said, major minerals you can tax in the second schedule at these rates. So now suppose it is 8% ad valorem, it's an all India tax. Whether you find the coal in Bihar or you find the coal in Karnataka, it's an 8% tax.
So feeling the heat from behind?
Very much, Manoj. Well, unfortunately, I can't be pushed in front.
Thank you, Mr. Datta. Now, Mr. Datta, you have to tell us who is following now next.
Mr. Ghosh is following. I mean, he wants to take 1 minute to.
Just a minute, I'll take. I'm going next subject to what is
No, no.
90110.
Bro, the tea tagging I'll give the note tomorrow in my matter.
90110.
I have only 3 points to make and I will not take more than 10 minutes. 3 issues have been troubling this honorable court. First, is there a possibility of a sovereign right of taxation to be ever denuded? That's the first thing. Whether the sovereign right of tax of a state can ever be denuded. That's the first question that has been troubling my lords. The second, has such a denudation ever happened under the current context? And third, whether the parliament can arrogate that right of taxation under 1897. These are the 3 very particular things, my lord. Insofar as the first issue is concerned, my lord, I'd like to place a judgment of the US Supreme Court, where the issue was of mineral right taxation exercised by the tribes, the Apache tribes. The Apache tribes under their formulation Lord, this judgment I had given it to the court master. This submission, this particular point is not there, this judgment, because I also fine-tuned my judgment based on the 455 US 130. 455 US 130 Marion. The opinion of the court was rendered by.
Compilation.
It's not there, but I've just, it has been given to the court master.
Marion, yes, he got it.
Yes, my lord. This was the case where, and I'll just briefly explain what had happened. The tribes, the Apache tribes were sovereign.
Yes.
They had the power to legislate and also impose tax. On minerals, they imposed a tax called severance tax. On non-tribe, non-Indians, so to say, and non-Indians challenged it. Issue that came before the US Supreme Court and the opinion of the court was by Justice Thurgood Marshall was sovereign's right of taxation cannot be denuded. However, the very wordings of the constitution of the tribes said, and I'll read that particular thing, my lord, text internal page 134. At the bottom, I'll just read the charter. Yes, please, yes. The bottom paragraph. This was the charter of the constitution. Inherent powers of the so-and-so tribe, including those conferred under section 16 of the Act of June, as amended, shall vest with the tribal council and shall be exercised thereby, subject only to limitations imposed by the Constitution of the US applicable federal statutes, and regulation of the Department of Interior and restrictions are established by this revised constitution. Very similar in construct, that your power of taxation can be limited by the US Constitution or the federal government. In this case, the same thing is happening as well. In that context, my lord, three things the majority opinion said. This power can be used to restrain the tribes, and I'll take, my lord, where it is, to abridge that right, and also to take away their right. All the things are possible. I'll take, my lord, kindly have page 141, internal page 141. Of course, second paragraph. Of course, the tribe's authority to tax non-members is subject to constraints not imposed on other government entities. The federal government can take away this power and the tribe must obtain the approval of the secretary before any tax on non-members can take effect. These additional constraints minimize potential concerns that Indian tribes will exercise the power to tax in an unfair or unprincipled manner and to ensure that any exercise of tribal power of tax will be inconsistent.
What is the next point?
Yes, Lord, that is one. So therefore, that is possible. Now, the second point is, if it is possible, then has it happened? Because the words used in entry 50 is that any limitation. And my lords have read the word any in the bearer bonds, in the electoral bonds case to means some, one, or all limitations. And therefore, it could go to anything. And reasonable restriction also has been meant to be a complete prohibition. It is our submission, my lord, that section 9 of the MMRD and the architecture of MMRD has actually imposed an entire restriction on the taxing power of the state qua mineral rights. We apply the aspect theory. There is one aspect that has been written there, which is the taxes on mineral rights. There could be other aspects, we don't know. Subject to the states having that power on that aspect, state can levy tax. But the aspect of tax on mineral rights has been taken over by the parliament by virtue of section 9, because section 9 has all the ingredients of a levy, of a valid levy as per Gangasaran and Govindsaran. The taxable person is there, mineral right holder. Taxable event is there, the conferment of the right and extraction of the mineral. The measure and value of tax is, the rate of tax is there in as much as there is a rate, specific rate that is provided. So section 9 is the only sphere qua mineral rights, because there is nothing left thereafter. Maybe there is other aspect of mineral rights that may be there, but that the state will have to find power, unlike the parliament, which has a residual power. And the third is whether the parliament can arrogate itself the power to taxation. Well, the submission is as follows. We apply the principle as applicable in doctrine of eclipse. My Lord knows, if a pre-constitutional law was ultra vires the fundamental right, it is not dead and gone. It is in a moribund state, which means it is inoperative. Applying the same principle, as soon as the parliament exercises the power under entry 50, that whole taxing power is in a moribund state. It is inoperative. The purpose of 248 is to deal with such subjects and such enumerations which is active. Because conferment of power means that you must use that power. If you cannot use the power, it is in a moribund state. It has to that extent become dormant and ineffective. Therefore, that cannot be there.
Thank you, Mr. Ghosh. Thank you.
Obliged.
Now, who's next?
Yes, my lord, as per Ghosh.
Anything over and above what has been argued?
Yes,
we'll note your appearance.
Sequence.
My consensus, sir.
So, the
Sorry?
sequence, as per sequence. Lord, as per sequence, I am supposed to do. Lord,
You can.
I'm sorry. Mr. Datar is
Not like your SLP day, Monday, Fridays.
I'm so sorry,
Lord.
Lord.
T20, yes.
I'm so sorry, Lord. As per sequence, I was supposed to come, Lord. I am
Kumar.
As per sequence, I'm so sorry, Lord. This has happened at my turn. Lord, I am only answering few questions which have been raised, and as per my submission, Lord, few new answers can be given to that, Lord. One question which has been repeatedly asked by, particularly by Justice Nagaratna and Justice Roy, Lord, that to what extent Parliament has taken over, Lord. And to that, Lord, Mr. Salve has referred that trilogy, and my submission is the consistency in all constitution benches except Kesoram Act, total inundation in respect of both regulation as
Not
well as
inundation, total denudation.
denudation, extraction, all denudation also a word has been used in Sandur, Lord. Denudation and Sandur and Bharat ko king coal has gone. Denudation.
Right.
Sorry. Bharat coking coal and Sandur has gone to the extent of saying that even executive power
All right.
under Article 1.
Let's
Lord,
start
when-
the other
when-
side at
Lord,
3:30.
Lord.
Give 1 hour.
Lord, when
We've already exceeded
Mr. SG was citing that
Thank
form,
you.
Lord,
We'll-
my Lord was looking
Thank
for
you.
substantive
Thank you,
limitation.
Mr. Kumar.
My Lord,
Just tell us
rule-
who are the others who, please give us your appearances.
Lord, 227, my Lords, there is substantive
Yes,
limitation.
yes, Mr. Dwivedi, please start.
9.7. In sequence myself.
Yes, Mr. Vasudev.
Sir. One point. New point.
Yes.
New point, sir.
पहले
9.7. 1 lakh.
new
point.
इसको सुन तो लीजिए।
Lordship, here I raise the point only fifth and
आपके
substance.
पहले
New point.
सुन तो लो जरा।
In sequence, sir, I
आपके
was.
पहले सुन तो लो। इतनी भी तो क्या जल्दी है? आधा घंटा है हम लोगों को। आपके पहले सीनियर काउंसिल है, तो 2 मिनट दे दीजिए।
That's it.
Just want to point out one fact. I beg to appeal civil appeal 945A of 2013. But we learn every day.
Yes, Mr. Vasudev.
I fear for the NTPC. They have given us submissions which are on record for supporting what everybody else says. I just wanted to point out a notification of the 1st of August 2077, issued under 2007, issued by the Government of India, which deals with the question of royalty and the calculation. And in paragraph 4, it says, for states other than West Bengal, levy cess or other taxes specified to coal-bearing lands, the royalty allowed shall be adjusted for the local cesses, because we have a situation where the local cess comes in. So you have a question of a royalty. Now, if the local cess is to be there, then in keeping with the constitutional scheme of having a standard tax or a standard royalty all over the country, the local cess should be included.
Thank you, we got the point.
In
Yes,
that-
Ms. Bhati. Thank you.
Just one more second, minute. In that context, I must say that in our cases, we are operating in Madhya Pradesh amongst other states as the NTPC, acting in the national interest. We are now being levied with a cess, which is very high, making it difficult to balance the finances with regard to the other states. So my respectful submission is this notification, cess should be a part of royalty, not excluding them. Of course, we will argue this before the other benches when it comes up. But this is a submission to your lordship. Grateful.
To appear for 2 of the coal companies, my lords. My written submissions are already on record. The only additional point that I've made, my lords, which some of the seniors have touched upon, is the Coal Mining Area Acquisition and Development Act, my lords, which is the regime under which we operate. And there, my lords, the levy is by way of an amendment. The Act is of 1957. The amendment comes in 1971, by virtue of which we are paying something akin to royalty on the same rates to the state governments. So, my lords, we have an alternate submission, but my lords, I wanted to bring that because as nationalized coal companies, we are, my lords, paying that to the state governments under that regime. Just 2 lines, my lords, I want to add, my lords. Firstly, my lords, your lordships are looking at the interpretation of entry 50, which is a taxing right, taxing power, but it is not eclipsed by a taxing power. It is eclipsed by a regulatory power. So my lords consider that aspect. The second thing, my lords. My lords, taxing power is limited, but the limitation itself is of very wide amplitude, because the entry reads any limitation subject to it being for mineral development. So the entry is smaller, my lords, and the limitation is wider, is my respectful submission. And though the entry is tax, but your lordships will not find a limitation which is of tax, because the entry does not contemplate a limitation of tax alone. My lords, one more submission, just additional, my lords, it fell from your lordships during the hearings, my lords, with regard to intergenerational equity. I also wanted to place, my lords, the aspect of intergenerational equity in, my lords, harnessing and development of the minerals and their usage in national interest for national infrastructure is an equally important component of intergenerational equity, my lords, that this generation has to bear in mind. I'm very grateful.
Yes, Patil. Yes.
Lordship, can I?
Yes.
Volume 2, page number 64. What is tax is nowhere defined in the Indian Constitution. There are 3 essential features of the tax in India.
First is it can be imposed by the public authority or the, you can say that is the government. Second, it is the compulsory contribution to the government. Pardon?
Who are you appearing for?
Appearing for the IA number 237364.
Who are you intervening for?
Private party.
Which private party?
Not getting, sir. In MADA versus sale. IA number 237364.
What does the private party have to do with this litigation?
Yes, sir. These minerals
Thank
are
you,
for
sir.
the ultimate use and the benefit
We
of the.
can't continue ad nauseum like this. All kinds of private parties can't come here. It's a dispute between the.
Sir, let me say I have the locus and I can say before you. These minerals are for the ultimate use for every citizen of the India. We in watches, in medicines, in everything of daily life, we use these minerals. So when the tax rates or the disputes of the center or the state are deciding that issue, then if the cost is higher, then every citizen will be impacted by this, sir. It is directly connected to every citizen of India.
All right.
Sir.
We are discussing and dilating upon the interpretation of three entries, my lord. Entry 23, entry 50.
That we now heard that for the last 3 weeks. Point.
The point is that the expression common in all the entries is mineral development. My lord, the entry 50, as my learned friend has just said, that is controlled by a general provision. Entry 50 is controlled by a.
Then why are you repeating what Ms. Bhati said? She made a very valid point.
Yes.
Don't dilute the point which Ms. Bhati made.
Entry 50, my lord. In Tolo.
Thank you. Yes.
In Tolo, your lordship has held that the entry 23 has been carved out in view of entry 54 of list 1. So therefore, the entirety of, as if it does not exist. That is why
it's not carved out. It is subject to.
It is subject to means that the area of entry 23 has been carved out from entry 54.
No. Please don't say that.
Therefore, my lord, there is no entry 23 existing. That is why the fees, whether it comes under entry 66, was denied. Second is, my lord, in the second point. My lord, I have given a submission, my lord, in which I have pointed out 10 flaws or errors which is committed in Kesharam, my lord. That has to be seen, my lord. I have given my submission.
Thank you. Yes, sir. What do you have to say?
My lords, I have an intervention on behalf of ESL Steel for Vedanta Group, my lords. Lot of submissions have been made on nature of royalty, whether royalty is akin to tax or royalty is a tax. My submission is converse, my lords. I am saying that royalty may or may not be taxed, but it is definitely not a consideration. And the proposition of law that I'm advocating is that any amount that a state or an instrumentality of a state which collects in order to perform a sovereign function, a constitutional function, or a statutory function, my lords, cannot be towards a consideration because what the state is doing is not a service, my lords. The consideration presupposes, my lords, whether it is understood under the contract.
So therefore, are you postulating that Vedanta can excavate as many minerals as it wants and you're not bound to pay anything?
My lords, what they're bound to pay may be in the nature of tax, but that's not consideration, my lords. So
you can excavate from the bowel of the earth without having to pay anybody. That's your submission.
Not, my lords, the nature of that particular payment may not be treated as consideration because
that means you don't pay any consideration at all. All right, thank you. Who else? Who else?
May I permit it also? Point second. Lordship, here I am discussing about the pith and substance. Doctrine whether law is valid by examining its dominant. Chemical engineering versus 9.901.7. Only two things here. One thing is lordship already pronouncement by the apex court.
So Data,
later on legislation.
I think we rushed you a bit. Mr. Rakesh Dwivedi can start in the morning tomorrow fresh. Is that okay? We have left for 20 minutes.
Yes, as a lordship.
I think that's better. Mr. Datar, we rushed you a little bit. We'll give you the last word. You can wrap it up for us. One second. Please now, let's not go from the sublime to the ridiculous now, please.
Wait, Lord.
Mr. Menon wanted to have 2 minutes.
Yes, certainly, Mr.
Lord, I had occasion to assist the Honorable Court in the larger bench in the Tresiyama Jacob, which everyone was referring to. That is, where in Kerala, the minerals are vested in the private persons. Now, in that one issue was left open was.
Mr. Menon, why don't you do this? Just close everything.
Yes.
And give us your core consciousness. Tell us what you would like us to.
My point was.
Just leave aside everything and just tell us what you.
Yes. My point is that.
Conceptually in your mind.
Yes, royalty and tax are mutually exclusive. And the royalty is a proprietary right, whereas tax is a sovereign right, prerogative right.
Yes.
Now, when state West Mineral, and as per the water principle, Halperis and all these principles followed by John Hogan, Tarragation, etc., it can be possessed separately. Minerals can be possessed separately because it's a subsoil right. Now, when you vest the mineral in the government, then government becomes the proprietor. Now, when you are saying taxation, it's a prerogative right. Can the state impose tax when you yourself is the owner? Yes, of course, for the time being, probably it appears, in fact, my duty to assist the Honorable Court. Now, when they are collecting royalty, they are the owners. How can they impose a tax?
Permitted by Constitution.
Now, so far as the taxing power is concerned, entry 49 and 50. Yes.
Make the conceptual difference that royalty is something which you charge in exercise of your proprietary right.
Absolutely.
Tax is something which you levy in pursuance of your sovereign power.
Correct.
When the same entity wields two hats, you are both the proprietor of the mineral and yet you are also a sovereign. So imposing both is not inconsistent because you are exercising your right as a proprietor in one instance, as a sovereign in the other.
In fact, one position I agree with, entry 49 and 50, these are to be read together. The entire power is vested with the state. I have no quarrel on that. Because entry 50 is carved out. Otherwise, the entire taxation power is there in entry 49. This is carved out for a limited purpose of bringing in a limitation by the parliament, by the law being passed by the parliament. So that aspect problem, I don't think I have anything. But when you are the owner, for example, let us assume that not in the case of a land revenue, and you are making an assessment and you are selling your own property. No. You are the owner. At the same time, you are exercising a prerogative right. Both these things cannot go together. The moment you become the proprietor, then you are not a sovereign, and vice versa. When you become the proprietor, you cease to be the sovereign. So when you are imposing a tax on your own property.
No, but it's not really, because what the state is doing is this. A private party, the lease owner or the leaseholder, has been given the right to extract. That private party extracts the material and extracts the mineral and removes the mineral. For that, that person has to pay royalty to the state.
Activity is being charged.
Right. And therefore, when the state now imposes a tax, it's not imposing a tax on itself. It's imposing a tax on a private party on the royalty which is paid by him for the extraction or removal of the material, of the mineral.
Yes. I got what's flowing from your lordship. So that's why, let's just have a look at entry 49 and 50. I'm not going to look, I'm not read out or anything.
Entry 49, entry 45 and entry 50. Entry 45 is land revenue. Entry 49 is land and building. And land is a bundle of right as per Hasbury, followed in Karageshwar or DK Trivedi or whatever it is. Now, out of that, you are separating this, as I already pointed out. Now, for that purpose, that power is always there with them. But in this case, why this? Because probably I'm arguing against this thing about this thing. I mean, a tax when it is being imposed, it is when the restrictions are being brought in to the MMDR Act, Section 9, what is being, more stress was given. According to me, it cannot be. Because Section 9 is only a regulation. And Section 9(3) read with Schedule 2. What they wanted to rely upon is it is rather a tax that's imposed falling under 366(28). It can never be. That's my argument.
Thank you. Thank
But
you.
I know, Lordship President.
Yes, Mr. Datta.
No,
we'll give
my
you-
only proposition was an honor, if they become the honor, and if you are, and what is mineral right? That is something embedded in the land. It is embedded in the land, you are imposing a tax on that. And only to that extent is governed by that particular limitation.
Thank you, Mr. Menon. Yes, Mr. Datta, we'll give you the last word. You can take us through to the end of the day today.
Great.
There are 2 points I wanted to highlight. One was where Mr. Kambata made a very important point, and because of time constraints, he could not do it. And it's the context of what my Lord Justice Roy asked the question, that in the Constituent Assembly debates, there was a move to shift it back to Parliament, and Dr. Ambedkar simply says, no, there is no logical reasoning. But one answer could be in the debates which came before the Joint Committee, and my Lord, my friend, House of Commons, yes. Lordship will just see the debates, give the volume. 4M, M for mother, starts at 54. And Lordship will just come to 56. I'm going to deal with that. And also Lordship asked the question, this tax on minerals versus mineral rights. That also I'll clarify. Yes, Lordship. 4M. M for mother.
M.
Yes, where is that? Yes. This. Page 56 about the third, Mr. Spence, I think must be Sir Patrick Spence. And Lordship will just come to just above the first paragraph, last line. Page 56. Lordship will come 5-6 lines down that. It starts the word, the first.
What are we reading, Mr. Datta?
No, we are reading a question where the matter was concerned by the House of Commons and earlier by a joint committee, whether the state should get an unlimited power of taxation or not. That was a short part. And there's a discussion. The other discussion is who owns the mineral rights and so on. That's not the subject matter from this bench. But what the bench said, I'll just summarize because time is short. The initial proposal in the draft was entry 54 was like the same thing. In that, at that time included oil also, but it was like 54. And the tax on mineral rights was not subject to any limitation. It was like tax on land and buildings, simply tax on mineral rights, taxes on mineral rights. That's all. When the matter came for discussion, Sir Craddock and Lord Percy, they said that, please see page 60. That sentence is important.
Page 60.
Yes. Yes. Please come to page 56. Second, the penultimate paragraph.
I have on a former occasion.
I have on a former occasion. My lords have got. I have on a former occasion referred to unfortunate results which have occurred in the United States and elsewhere, where a variety of states have been allowed to deal with proprietary rights and regulations affecting the minerals of their own district. The same thing will happen in India. If you have 11 states making their own laws with regard to rights of owners of minerals, whether they are vested in the crown or in private persons. It is exactly the same thing with the important question of taxation of minerals, one state imposing high taxes on mineral rights and other state imposing a different scale of taxation. This only leads to confusion and to a very, very uneconomic and non-commercial development of the mineral resources of a country. Therefore, I urge that as far as possible, we should take this opportunity to bring about one code of laws relating to as many minerals as possible throughout India. Now, please come to the, direct on page 60.
59.
Yes. 59. At page 59, and Lordship, this is made at 7:19 PM. Lordship has got a Lord E. Percy. At page 59.
By written submission.
We are following.
This is, I have quoted.
We are following.
So
No, page 59.
Not Percy.
I have quoted,
Yes, I noticed Lordship has got 7:19 PM.
Yes.
Yes, my lords have got it 7:19 PM, yes. I noticed that the government are not proposing to remove taxation of mineral rights from the provincial list, where it is now. How can the federal government have power to regulate the development of mines if an unlimited power to tax rights is still left in the provincial legislature? Then the Solicitor General answers, and kindly come to the second paragraph. I now come to the questions put by my honorable and learned friend, member for Ashford, Mr. Spence, and the subsequent speakers. My view certainly is that these words clearly cover the power of vesting minerals in the Crown. The words would clearly entitle the Federal Assembly to make provisions as to concessions, and the words of amendments are wide enough to empower the federal legislature to cover all matters in development of mines, coordination, and so forth. Now, my lord, please come to find page 62. 60, no, the taxation.
Yeah, this is it.
Yes. Please come to page 60. And please come to page below the Solicitor General, below Mr. Molson. Lordship has got Molson. Yes. Please, Mr. Molson. I'll read Mr. Molson, my lord. The learned Solicitor General keeps on referring of leaving it to the provinces. The responsibility for developing oil and coal is at present with the government of India. What is being done under this is to transfer the primary responsibility from the center to the province, and at the same time, provided subsequently, it may be retransferred from the province to the center. The Solicitor General, I was speaking of the bill as originally drafted and comparing it with the result which will flow from this amendment. In the original bill, mines and minerals were exclusively provincial. Many matters which are now central are being transferred to the provinces, but would be out of order to go into a larger issue raised by my learned friend, member of Hastings. Lord Percy raised an obviously important point into which we shall certainly look. I can quite imagine a form of taxation which would conflict with regulation and development. In that case, I think I'm right in saying that under this scheme I have in mind at present, list 1 wins. If there is an overlapping between list 1 and list 2, list 1 wins. And this amendment was accepted. Yes. And we come to page 62. Page 61 is a speech by Sir Reginald Craddock. And just the last two portions. Page 62, my lord. Second paragraph. There is a further point. Lordship has got that. There is a further point. There is a further point that great discrimination might be caused by heavier taxation being imposed in one province than in another. If mines were being worked in one province, say by a European or a Parsi, and mines were being worked in another province by persons of some other race and status, it would be possible for a province to bring about discrimination. One province might put a heavy tax on a European mining concern, while other province might put a low tax on an Indian mining concern. There is a great necessity for maintaining control of central government over the rates of taxes and so forth, merely with a view to securing uniformity. The other royalties and income would go to the province, and the province would go in the ordinary way, as they are doing now, administering those matters which they administer at present under mining rules and royalty rules, etc. Yes. If they want to alter these rules, they would require the sanction of central government. It is that way that uniformity can best be secured while allowing the provinces to have legitimate income from their mining concessions, and at the same time avoiding all risk of discrimination between concession holders of different races. Lordship can say now different states. I thought that these facts, derived from personal experience, might usefully play before the committee in consideration for solution. Really, wording is because of uniformity. My learned solicitor says on page 37 to 50
of my, more on this era.
Yes.
Yeah.
So this debate shows why tax of mineral rights was subject to a law made by Parliament to maintain uniformity, as I said, to impose financial guardrails, financial limitation. That was the proposal. But questions came from the bench.
This is the control.
Yeah, my friend points out that this was the confusion which was sorted out eventually by the 1948 Act, saying that, look, there'll be a Mines and Mineral Act. Yes, and perhaps that could be an answer why Dr. Ambedkar felt that, look, there is no need to interfere with what was the earlier position. So you have entry 54, entry 23 and 50. Now the last point Lordship asked on taxes on minerals and mineral rights. I just put forth what I think, Lord. In para 400 of Justice Sinha's dissent in Kesora, his Lordship rightly points out that mineral rights are embedded in the earth. Only when the minerals are won do they become minerals. Only after the mining is done, excavation is done, they become minerals. Now, on the taxing of minerals, I would just submit, Lord, because entry 84 of list 1, I'm talking of the pre-GST era, refers to goods manufactured or produced in India. Entry 84. There are judgments which say that coal is produced. Nobody can say coal is manufactured because it is in the earth. It is one, and once it is one, coal becomes produced. Then it is beneficiation takes place, purification. So coal is produced. Coal is entry 2701 of the Central Excise Tariff. Lignite is an entry. Coking coal is an entry. Petroleum is an entry. Crude oil. So maybe once the goods are produced, the taxable event is the production of the particular mineral that could be subject to Central Excise Duty. Suppose the mineral is sold. Sale of mineral will be subject to sales tax. So maybe in the context of minerals, at the mineral right stage, the taxation is on the activity of excavation, mining, whatever it is. Because once a mining lease is given, the definition of mining lease is the activity of trying to win the mine from the mine which you got a lease. So mining rights is 50. Once the coal is produced or minerals are produced, and if they are mentioned in the tariff, it will be entry 84, list 1. If the minerals are sold, it will be entry 54, list 2. This could be the architecture of the taxation powers, is my humble submission. And again, Parliament has been very careful. Under section 14 of the CST Act, coal, iron ore, many minerals are declared goods. So you can't tax more than 4%. This was 3%, it became 5%. And you can't tax at more than single point. So if it is taxed at a coal, say, Neyveli Lignite Corporation taxes at the point of pithead, subsequent dealers, when they sell, it can't be taxed again. So this is my submission on tax on minerals and mineral rights. That's my submission. And not the only issue of subsoil, etc., we leave it later because this is yes. Right.
Lordship, can I get 30 seconds, Your Lordship? I'm appearing for one of the interveners. Can I just get 1 minute, Your Lordship? That's all I'm praying for.
Who is the intervener you are appearing for?
Your Lordship, it is IA number 55372. It's one Ganpati Eat Udyog, and there are other 800 petitioners for which separate SLPs have been filed. We have provided the list as well. Your Lordship, this is concerning the GST.
Seth, which corporate group have you been sponsored by?
No, not at all, Your Lordship. All we'll see.
All right, thank you, Mr. Seth. We'll conclude here.
My lord may allow.
Sure, just 1 second.
Yes.
No, I do not know whether the present audience can answer the question that I have.
Yes, we'll try, Manoj.
Because Mr. Salve should be the right person, because this House of Commons debate that you are discussing, they're giving the timing also.
Yes.
This timing, does it relate to happy hour or something?
My lord, allow.
Happy hour. Honestly, we have been seeing, none of us thought about this so far, Lord.
Because we are not concerned.
Lord, because Lordship reads the biography of Rufus Isaacs, Lord Reading. So he used to be in court till 5 and then go to the House of Commons. We used to be KC MP in those days. And then the Parliament would go on in the evening. So after court house, Parliament would start and go late into the afternoon.
And in the ante room of the Parliament, they used to serve.
So, if it would not have been there, Winston Churchill would definitely have introduced.
Lord, allow.
Mr. Dwivedi, so we'll start tomorrow morning.
No, really,
I need one liberty to circulate.
Extremely grateful to your Lordship for the
on criminal development and its effect on taxation. 1 page.